Um, Hello, everyone. Welcome. I know our attendees are coming in here. Let me go to my different version here. Okay, welcome everyone. Let me pull up our initial slide. So we have 26 members of the public. I know people sometimes want to know and make sure we're not including any of our analysts. Okay. So welcome. This is the third meeting of the Nantucket Short-Term Rentals Work Group. Our meeting objectives for today is we're going to clarify some legal questions. We sent out materials in advance for each of these topics, but this will be a chance to get a little bit more information from our experts who are here to help and support the group. So we're going to have some conversation about the legal issues. We're going to talk about Nantucket zoning, and then we're going to delve into policy levers and the range of possible policy levers. So here's our agenda. We're going to take a little bit of time for some internal group work, mostly just a little bit of get to know you a little bit more. Since we are not in person, we're going to do our best here over Zoom. Then we're going to get into the legal issues, zoning 101, the policy levers. As we said, we'll have time for public comment. And then as we move to wrap up in next steps, we'll talk a little bit about schedule and timeline going forward. Also to hear people's anything people want to weigh in on, since I've been asked to update the select board tomorrow on our progress. So to hear if there's any other questions people have for the select board that you would like me to bring forward to them. Okay, so norms as usual, please. Primary members, if you're willing and able, bandwidth wise, to have your cameras on, that's super helpful. For all others, the alternates and our technical team, feel free to turn your cameras off for now. Technical team members, of course, you'll be invited to turn yours on if you're asked a question or if you're presenting. Raise your hands to speak. Your Zoom hand. Mute when you're not speaking. Please feel free to use the chat. We are recording this meeting. It will be shared. We will get to the public questions and Q&A at the end of the meeting. If we have a chance to answer them during the conversations as appropriate, we will do so, but otherwise those will all be addressed at the end of the meeting. All right, our meeting ground rules, now that we have passed those as a group. This is sort of my short version of them, but to please try to be constructive, to stay on topic, to be respectful and civil to each other at all times, to share your real thoughts and beliefs and concerns, to be concise, and to try to keep an open mind. to each other and to the information that we are discussing. Okay, so now let me turn to approval of the meeting summaries. So we did not do our approval of our meeting 1 meeting summary at the last meeting because Mary had not gotten the email, though I did check and see it had been sent to her, but somehow her email did not come through to her. So I want to make sure now that we approve the meeting summary from October 11th meeting, and then we'll turn to the meeting summary from October 25th. So meeting summary from October 11, yeah.
Is Mary even here yet?
I do not see Mary, but she doesn't get to vote anyway.
Okay, that's true. All right.
And she did tell me that she did receive it. I did chat with her between last meeting and this one.
Perfect.
So I know she received it, and she did not send us any comments.
Okay.
Thanks for that, David.
So you're looking for a motion to approve?
Yes.
I'll make that motion.
Okay.
Second.
Great.
Second.
Any discussion? Okay, all in favor?
Aye.
Aye.
Great. Any opposed? Okay. October 25th meeting summary. Any discussion? Okay, anyone want to make a motion to approve them?
I'll make that motion.
Second.
Second.
Great. Anyone in favor, say aye, raise
Aye.
hands.
Aye.
Aye.
Any opposed? Okay, thank you. So those 2 meeting summaries, October 11th, October 25th, meeting summaries are approved. Great. Okay. So with that, before we move into our first presentation, I was wanting to invite all our primary members to just do a little bit of a go round. I think I'd like to try and incorporate this into meetings to the extent people can tolerate, at least just to take, 10 minutes to help us humanize each other and get to know each other a little bit. So I wanted to ask a question, which is a meaningful memory of Nantucket for you, something that strikes you, sticks out for you, that you talk about, that sort of encapsulates something you love about Nantucket. So try to keep your answer to, a minute or so. And I will invite the first person who wants to share. Great, Peter Schaefer. And then what I'll ask Peter is, when you're done, to just pass to someone else.
Okay. It was hard when I started to think about it, but then it popped into my mind. I love a lot of things about Nantucket, but most of all, it's the people. We retired here 4 years ago. We've had a house on the island for 35 years, but we have more friends now on the island than we had when we were back in New Jersey. And to me, it's a neat thing. So the people on Nantucket, the year-round people especially, but all the people are what I love about Nantucket the most. David.
Thanks, Peter.
David's one of those people I love.
It was such a quick question, and I think about it, and I go back to Peter. I think it's people. For me, if I was to think of kind of some moments that really were important to me, for years we did a surf contest out at Cisco, and it really became a really big community event where the community would come together, would help put it on. It was a one-day event. The kids had an amazing time. There's prizes and stuff, but most importantly, we raised money for Meals on Wheels and the Boys and Girls Club. And it was just amazing to see the community surround a positive, fun, exciting event. And that is a great memory for me. And I'm going to pass this off to Jim Salzer. You're muted, Jim.
Thanks, Dave. So much to love about Nantucket. I was just out family scalloping the other day and many, many things like that. But I'm going to go to people also. I was a teacher for years, for 30 years. For instance, having the class put on a play or a musical, having the kids get up there, show confidence, and the parents are there and their grandparents are there and friends of the family. And then there's younger kids in school who see it and come up and say, I want to be Ares next year, or I want to be Athena. You know, it was a Greek myth musical was one of them. But just seeing that connection of the people and of the bonds of affection that spread out in all directions is very special. Okay, and I'll pass on to John.
Thanks, Jim. So Stacey, your first slide said be sincere, so I'm going to be. Yeah, my memory is about people, but actually not people, a person. And I lost my middle daughter a few years back, very young. She was only 35. But this island is where I connect with Millie. And she came here from when she was a kid, when we were renting. She came here a little later, you know, pretty well every other year, you know, after I bought my first house here. And Millie loved this island. And we connect pretty well every day on this island. She sends me rainbow messages and all kinds of messages. So, yeah, this is where I connect with my daughter in heaven. And I'll pass on to Kathy.
Wow, that's a hard act to follow. I think for me, it's, I'll never, every time I go into the whaling museum, I see that whale skeleton up there. I was on the beach with my kids when that whale washed ashore. And the one thing I'll never forget, two things. One is that it was still alive and it's a mammal, and whales have eyelashes, just like we do. And that whale was looking right at us, looking for help. And I'll never forget that feeling, as well as the community of people who were trying to save that whale. It wasn't successful, but these are whaling families from back, you know, centuries ago. And they were all there trying to, as a community, do something to save that whale. And so the whole community organization, the whole way of Nantucket community and coming together when there's something that needs to be done is something that I really love. And I will pass it now to Karen.
Ooh, so many. It was hard to pick, but the first thing that popped into my mind was just spending the time with my grandparents and my cousins and my sister. My grandfather was a real taskmaster and he had this huge garden. And so he used us as kind of slave labor, and we would be weeding and planting and then making zucchini bread and pickles and all kinds of things. And so the morning was always devoted to doing things like that. And then the afternoon was fun and play and go to the beach, and he'd throw us off his shoulders into the water and those kinds of things, and beach picnics. And I'm as close as I am to my cousins and my aunt and uncle and so forth, because we got to spend time on Nantucket together because we lived very far apart. And then in the afternoons, we'd go down and see people on the lane. And it was the same people every year. And I babysat for people who had babysat for me. It was like a multi-generational thing where we would multiple generations of babysit for each other's kids through the years. So those are my, so let's see, Thomas, have you gone?
Sure, I'll go. Yeah, so like John, I don't want to be maudlin, but that's the first thing I thought of too. I lost both my parents when they were fairly young, and Nantucket is where I've come to heal, and it remains that place. I don't know if it's our salt air or it's the people or all the above, but it's a very special place. Oh, I'll throw it to Julia.
Thanks, Tom.
I guess I would go back to when we first moved to the island. I was, I think, 35 weeks pregnant with my second child. And it seemed like a great idea to move at that time. And I was fortunate enough to be at home for a few years with the babies. We were raising young children, and I could never have imagined a more perfect place to raise little kids, running around the yard, gardening, going to the beach. Actually, when my son was born, 3 days later, he was wrapped up around me on my chest, and we were driving on the beach, and at Smith's Point, and we saw the doctor who delivered my son, and he said, "I guess you're doing okay." And I thought, yeah, this is the most amazing thing. I was in the hospital 24 hours ago. You can't really make this stuff up. And there's so many great memories, since then, of just raising those kiddos, and I feel really fortunate. I will pass it on to Peter.
Thank you. Can you hear me?
Yeah.
Okay, great. I guess my favorite memory is when we started coming as a family in 1987. We were at the Wade Cottages with our very young children at that time. We continued to come to the island for many years, and then built a home in 2009. And the kids continued to come. They were no longer kids as young as they were, but now they have kids, and so we have grandchildren who are now coming to the island. And it is a special place for family. And also, of course, we've made, as someone said, we've made many, many friends. We probably have a more active social life here on island than we do in our primary residence, but we're spending probably now more time, 6 months a year on island. And I must also add, I enjoy lunch at fairgrounds with some friends every week.
Great.
I'll kick it over to.
I think we got everyone.
Okay. Okay.
Yep, I think we got all our primary members. So thank you all for sharing. And that was really, really nice to hear a little bit about you and, why this place is so special for you all. So with that, I would like to move us back into our work and hand this over to Alex. Alex, I had turned off your video because I just wanted our group on, so you can turn your video back on if you're able.
All right.
And then I will.
It's saying I cannot start the video because
Yeah, you can do it now.
Oh.
You should be able to do it now.
No, it's still saying I can't.
Samanish, do you know how we fix that? Oh, wait, let's see.
Yep.
Start video. Okay, try now.
There we go. Oh,
There you go.
there I am.
Once I turn it off, I guess I have to invite you to turn it back on.
All right.
Shows what I learned. Okay, there you go.
All right. Well, before I get started, I'll share a quick memory I have of Nantucket. So my wife and I actually spent our mini moon on the island after we got married in 2014. And we stayed at the Nantucket Hotel for a long weekend, and it was during restaurant week, and the food was unbelievable. We took a Jeep out to Matagat Lighthouse one day, and just the beautiful natural serenity of that beach was just really, really breathtaking. So that's a very fond memories that I have. But anyways, getting on to legal issues. So I figured it would probably make sense. Hopefully you've all had a chance to take a look at the responses that John Giorgio and I put together for the questions that the group had sent to us after the last meeting. And so I figured I would start by just taking some time to kind of summarize our responses there. And then from there, we can move on to any further questions you might have, or go in, whatever direction you'd like. So, starting from the top, the first sort of issue that was raised was, once a bylaw is enacted, be that a general bylaw or an amendment to the zoning bylaw, how would grandfathering protections play into the new bylaw provisions? And so the answer to that varies based on whether it's a zoning related bylaw or a general bylaw. So under zoning, the State Zoning Act, which is Chapter 40A, has a provision within it under Section 6 of Chapter 40A that well, and actually the courts don't like to use the term grandfather anymore. They call it a pre-existing non-conforming use. So pre-existing non-conforming uses are uses which have been in, or were in existence and were lawful until such time as an amendment to the zoning bylaw made them unlawful. And if they were in existence before the amendment to the bylaw, they may continue consistent with how the use was in place prior to the zoning amendment. So that's sort of a statutory legal doctrine that applies to zoning pre-existing non-conforming uses. When we talk about a potential general bylaw, there's not sort of a statutory legal doctrine that would apply, but instead we would have to put specific language into the general bylaw stating if the group wanted to apply as give some sort of rights to pre-existing non-conforming use, or however you wanted to treat existing rental properties. We would need to sort of craft some specific language for the general bylaw to make it clear that uses that are already in existence, if you want to treat them differently from future uses, we would need to specify how you wanted to do that. So that sort of generally addresses the, and sorry, Peter, I see you have your hand raised. I'm happy to answer questions as we go along. So go ahead, Peter.
Yeah.
Okay, just real quick, Alex. So let me make sure I understand this. Somebody owns a house now. They've been renting it. I don't know whether it's what you would consider what was the word you used?
Pre-existing non-conforming.
Non-conforming. Yeah,
Yeah.
I mean, not sure that renting a house is non-conforming or not, but let's just say it is.
Mhm.
And we pass a general bylaw. And if there's a stipulation in our general bylaw that nothing is grandfathered, does it not open us up to about 2,700 lawsuits?
No, in that to the extent that it was passed at town meeting, town meeting being the legislative body of the town, there is statutory immunity for municipalities for when bylaws are properly enacted. That said, I think the practical implications of that are something you all should definitely consider, and probably would be in everyone's interest to consider including some type of provision to deal with, existing operations potentially versus future operations.
And would there be any difference to somebody who borrowed money based on a bank requiring that it was rented, and we change the law? Would they have a better stance or better agency in a lawsuit?
Again, I think there are statutory immunities that would likely apply, but it's something.
Okay, it would be
It's
difficult.
something to take seriously. Yeah, I think it's if we're going to go with the general bylaw, I think consideration of how to treat existing uses is definitely something we want to address carefully.
Okay, thank you.
Julia, did you have a question?
Thank you. Alex, so in the first part, you mentioned that if under a zoning bylaw or under zoning, pre-existing non-conforming uses are those that were lawful before an amendment or a clarification, or I will call it an amendment to zoning.
Right.
On page 5 of town council's memo, he mentions that, again, it's sort of the use has to be lawful before zoning is changed.
Mhm.
There seems to be uncertainty as to the town's position as to whether it's an existing lawful use. Well, STRs as a whole is a big use, right? There's a lot of maybe, principal use, accessory use, there are different nuances there, but what's the position of the town on what would be lawful right now?
So my understanding of the current position of the town's zoning enforcement officer, so building commissioner Paul Murphy, who I've worked with quite a bit, his position is that STRs are allowable accessory uses to a primary residential use. Now that position is currently being challenged in land court. So, we don't have a definitive ruling from a court yet on that issue. But that said, one of the goals of this group is to try to deal with that uncertainty by enacting a bylaw that, clearly says this use is allowed in this way. So that's, we're trying to take away that uncertainty here.
Thank you.
David?
Thank you. So there's also with pre-existing non-conforming, if that use doesn't take place for a certain period of time, you lose that, correct?
Correct. It's normally 3 years. I would have to check your bylaw quickly to confirm, but normally it's 3 years.
Thank you.
Yeah.
Yes, real quick, Alex. Thank you. This is all great. As far as the question about people who purchased properties and went to banks for loans, and one of the stipulations was that they rent it, I just wanted to point out that even if we removed, or if a bylaw removed the ability for STRs on that property, they would still have the right to rent it non-STR. So I would really doubt that the rental agreement would call for them to rent short-term rental as opposed to whatever, year-round or whatever.
Yeah, agreed, Jim. Year-round rental would be an as-of-right use.
Yeah.
So yeah, I tend to agree with you there.
Yeah, just a minor point, just wanted to make. Thank you.
Peter?
Here's a question of a year-round rental on a house that rents for $40,000 a week in the summer. It'd be $40,000 a year on a year-round rental base. So they wouldn't be able to pay their mortgage. So I disagree with you, Jim, on that. I don't think that, maybe legally, but they would
Right,
still have.
I think this is a legal
Agent.
question, the legal
Right.
question that they're discussing, not a financial benefit question. David?
Yeah, I know you want us to tamp that down, but I think to you, Peter, I think that most banks don't really, I think that the short-term rental thing's a weird thing. Banks, if they want a loan on rentals, they want a lease, a year-round lease. So I think a lot of banks really don't base their decision on lending money just on short-term rentals. But I could be wrong, but that's my understanding. Thanks.
Yeah. Thanks, Julia.
Alex, if you don't mind going back to the town's position on what's lawful right now, there's some confusion, frankly. I mean, everyone knows that Act Now is supporting some of these requests by abutters to enforce against, let's use an example of a purely commercial STR, right? Like there was one at 14 New Mill a couple of years ago, the property sold, and 32 Monomoy would be the most recent one.
Mm-hmm.
The town, I mean, it's only a short-term rental. There's no doubt in anyone's mind that there's no residential use or long-term residential use on these properties. The town has denied the request to enforce against this purely commercial, but you're saying that the building commissioner's opinion is that it's allowable only as an accessory use, but that's conflicting with what has been pursued, isn't it?
My understanding of his position, and I'm sorry, I don't know the specifics of the property you're talking about, but you know, in general terms, it's my understanding that it's his position that if you have a primary residential use of the property, that an accessory use for STR is allowed.
Okay, thank you.
Yeah. Okay.
And I would note too that, you know, that position, although it hasn't been vetted out in court, there is case law that suggests that when you're evaluating whether or not this type of use would be a lawful accessory use, you have to look at the specifics of the community that you're dealing with. And when you're talking about a community like the island where, you know, I think John told me there's something like half of the housing stock is short-term rentals. That's different than other communities. So just something to keep in mind.
Yeah. And, you know, this group is not going to resolve, like there's a lawsuit, the lawsuit will resolve those questions, right? It's for this group to, though, to sort of move forward whatever regulations and policies you all think are the right ones for going forward. So, and, you know, for Alex to give us guidance on sort of what the law allows or what's sort of possible within the legal frame. So Alex, were there others of the of your answers here you wanted to go specifically?
Sure. So, you know, I think the initial issue was the pre-existing non-conforming protections. And then related to that is the question of, you know, and this is obviously a very important policy decision for you all to make, but are we going to pursue enactment of a general bylaw or a zoning amendment? And there are some, you know, procedural differences there. You know, town meeting approval for a zoning amendment requires 2/3 approval versus a general bylaw, which is just majority. You know, our opinion is that the statute, so General Law Chapter 64G, Section 14, which is the fairly recently enacted short-term rental statute, allows for either a zoning bylaw amendment or a general bylaw. And, you know, we believe that position is further supported by a fairly recent Supreme Judicial Court decision involving the town of Bourne, where a general bylaw prohibiting retail marijuana establishments was upheld as lawful. And the court's reasoning was based on the fact that the town had not previously regulated marijuana establishments through its zoning bylaw. And, you know, similarly here, Nantucket does not at this point explicitly, you know, regulate short-term rentals through your zoning bylaw. So I think that based on that case law, that sort of gives us the flexibility of going either way. Now, you know, when you're talking about a general bylaw versus zoning, there are certain classes of ways to regulate the operation, and there's 4 specific ones that are listed in the statute. So the first being regulating the existence or location of the operators of the STR, regulating the classes of the operators, which, you know, could include properties that are not owner occupied or that are operated as a commercial use. Third, placing a limit on the number of short-term rental units that are allowed throughout the island. And finally, regulating the number of days a year that an operator can, you know, rent out the property. So, you know, these sort of 4 categories, although not necessarily exclusive, are, you know, something that we should try to adhere to if we're going to go the general bylaw route. You know, and then sorry, go ahead, David. I see you have your hand raised.
Alex, I didn't mean to interrupt you.
Oh,
Why don't you finish your thought and then I'll ask a question afterwards.
okay.
Yeah.
Yep. And so, so that's with regard to, enacting a general bylaw. I mean, similarly, a zoning amendment should also generally adhere to these 4 categories, but there may be a little more flexibility there in terms of regulating the actual use of the property rather than just the operator. So, that's, and when we get into that distinction, it gets kind of fact specific in terms of, what aspect of the use are we trying to regulate, or are we talking more about, who can rent the property, how often can they rent it, things of that nature. I think with the zoning, you may be able to get a bit more specific in terms of how you regulate the actual use. But that's something we can talk about on sort of a more distinct factual basis, depending on, what what specific issues you guys are concerned with. So
Yeah,
that's what I had for that sort of general distinction there. All right, I see a couple questions, so why don't we
David.
touch those, David?
Yes. So I guess what I hear you saying is that really, in some respects, that this is going to probably be best regulated through both, right? So if we decide to go the bylaw route, we still need to have the use chart piece in there, and it needs to connect with whatever bylaw it is to make it whole and work, correct?
I think that would be ideal. I think the sort of uncertainty that we have now with, is it an allowable accessory use, and the sort of the issue that's being litigated. Yeah, I think addressing it potentially both ways would be ideal, but it's not, it doesn't have to go that way, but you could do both.
Okay. And then, and again, I'm not speaking for the group. This isn't a request from the group. This is just me asking. If we as a group decided we wanted to go a certain way, would you be able to suggest an article? And the reason I ask is because I think that the intent of 29 wasn't fully embraced in the article. So
39, David, you
I mean, yeah, 39, I'm sorry. So if this group asked you, if this group decided as a whole to ask you, would you be able to suggest an article for ATM that would give the select board the right to regulate the, existence and location, class of operator, and placing a limit on the amount of short-term rentals? Would you?
For a general bylaw, sir.
For a general bylaw, if this group decided to do something like that to fill their toolbox, would that be something that you would be able to help?
Yeah, absolutely.
Okay. Great. Thank you.
Yeah, and just to note, the tools available to this group, we also have Judy Barrett, who's going to be presenting, and she's also going to be able to be available to help us with writing of bylaws. I think we're going to have the legal side, we're going to have the zoning and land use expertise, right? As well as, of course, Jeffrey's help. All of those are available to the group once the group decides what it is they want to try and move forward.
Awesome. Thank you.
Julia?
Thank you. It's actually a lot of Dave's question answered mine, but let me just ask in a slightly different way. So there seems to be acknowledgement that the zoning needs to be addressed in some way. That Styler has created a lack of clarity in our zoning bylaws as to whether STRs are an accessible or is a an allowable use, even as an accessory use. If the group decided to simply go with a general bylaw, and I understand that, you know, it's easier to pass general bylaw, wouldn't, and not dealing with zoning at all, wouldn't, how would that solve the problem that really led to the creation of this work group, which was, you know, we need to fix our zoning? I mean, that's part of the issue. Obviously, there's some issues with dealing with the impacts of STRs, but I think that's a common idea.
Yeah, again, I think you'd be dealing more on the operator side of saying, you know, this class of operators can apply for licenses.
I guess sorry, Alex, I don't want to
No,
waste
that's
your
okay.
time, but like, is it, my question is, how would just moving forward with a general bylaw fix the problem that's in the zoning?
It probably would not.
Okay.
So sorry, so just to be clear there, Alex, you're saying if the group passed a general bylaw that regulated the operation of STRs, the legal questions behind these lawsuits would not be resolved by such a bylaw? Is that what you are saying?
Well, if there were a bylaw in effect, obviously I can't predict what a court is going to say, but I think if there's a bylaw, even if it were a general bylaw saying, you know, the island supports these types of uses, even though we're not, hypothetically, say the zoning didn't pass, but we had a general bylaw, at least, you know, we could say to the court, well, look, the legislative body of the town has enacted a general bylaw regulating the use. You know, historically, it's been treated this way. They're still clearly supportive of this type of use. So in some ways, I think that would probably bolster an argument that it is currently an allowable accessory use. But again, I'm not a judge.
Yeah.
So ideally, again, I think probably both would be ideal.
Yeah. Okay, Kathy?
Thank you. So first, I think on the fact that we have Article 39 and that we're actually having short-term rentals register with the town kind of implies that the town is supporting the idea of short-term rentals existing in some way. But my question really is on we've been using the term accessory use. Can we define something that, you know, like along the lines of how do you define accessory use when it's not feasible? For example, a property that's not winterized, or, you know, like a lot of cottages in Sconset, or some of them that are on the wharf, they're not habitable year round, or the owner can only make it 2 weeks. How do we define accessory use in the legal terms? That's the question. Thank you.
Sure, good question. So the sort of zoning definition of accessory use would be a use that is minor and incidental to the primary use. And, you know, the case law addressing STRs, I believe is a case out of Swampscott, you know, talked about how, you know, questions like how often out of the year is the owner of the property present at the property? You know, is it really a primary residential use, or is it more of a commercial use? And there's not a fine line there. It's a very fact-intensive inquiry when you're dealing with STRs. So I'm sorry, I can't give you a very clear answer on how that would apply to the island, but I would say that, you know, Building Commissioner Murphy interprets currently the bylaw as allowing STRs as an accessory use. That's his position.
Okay, so basically, if it's a house, doesn't that mean it's a residential use if people are living in it?
Yes, but so there's a distinction between Yeah, so the primary use would be single family use or potentially a multifamily use, right? And the accessory use is, yeah, are we not dealing with the owner operator living at the property primarily, or are we talking about something that's primarily just a commercial operation?
So vacancy isn't a use. So in other words, if the house sits vacant, what's its use considered to be?
I mean, if when it is used, it's used by the owner, then it would be probably a single family use. Yeah, I think, I guess if it was, yeah, so when you're, that's a good question. So, is the concern that, well, I guess what is your concern with that, Kathy?
Well, it's just that I just, in following this issue for a long time, there's been so many people that have said, well, it's a cottage. It's not got year-round use. It can't be lived in year-round. It can't be defined as a principal residence by anybody, including the owners. So what do you do with homes like that? How do you consider them? How does that mix it in? Or does it look over multiple years of use? How do you look at these kinds of situations? And I think we've got a fair number of them on the island, and people are wondering, they're like in a limbo zone. What are they? So that's really the question.
No, understood. Well, so if that's, and we can look at the specific language in the zoning bylaw as it exists now. And if the group feels like there's a need to specifically say, how often does a property need to be inhabited by the owner in order to be eligible, that's something we could consider including.
Right. I mean, I think if the question is like, is there a clear legal line right now between accessory and primary uses and how STRs fit in those? I'm hearing you say, Alex, I mean, are you saying there isn't quite a fine line to be drawn, and given the position that the town has taken, that the use that the houses that are in the cases that the lawsuits involve, they are saying that STR is an acceptable use because it's an accessory use. They are not counting days or differentiating between primary and accessory. That doesn't mean a court won't, but that the position of the town so far has not done that.
Right. And I think the distinction definitely could use clarification, and that's something that we should consider with the bylaw amendment.
If 85% of short-term rentals are owned by and operated by part-time residents, that's their primary use. Maybe, I don't know.
Well, that will depend on what the language says in the.
Right. Okay. Thank you.
Peter.
Just for clarification, Alex, some people have spoken and talked about things being legal or not legal in terms of rentals on the island currently. Is it fair to say that right now there are no regulations and you can do whatever you want when it comes to a short-term rental?
Well, no.
I'm talking about renting it. I'm not talking about anything else. I'm just talking about renting it.
Well, no, we have the rental regulations that are in place now.
Right, but as long as okay, let me be direct. Julia talks like people are violating the law by renting houses. Okay, and she's involved, her group is involved with some lawsuits against houses that are rented that they don't think should be rented, whether they're owned commercially or not. I'm not trying to discern that at this point. All I want to know is, right now, if you're meeting all the town regulations, you can rent your house on Nantucket?
Yes.
Thank you.
Julia,
Now I'm more confused. So, okay. It is important to talk about the whole accessory use idea just because that's the position of the town, right? And what would be the pre-existing non-conforming use, presumably, if a zoning bylaw was enacted. At least that's how I'm understanding it. What would be protected, which may be completely acceptable. Article 43 was a version of accessory use. And we talked a lot about it because we too found the term, quite frankly, confusing. And it sounded like the zoning board of appeal had some leeway in terms of what it could call accessory use or in the first place, which is maybe why there's no line in case law, right? There's some ability to be a little bit nuanced. But what sort of Kathy was asking was, if there's a limited available use of a property, let's say 3 months or 4 months or 5 months, and then that just becomes the window of use, right? And so the question of principal use doesn't have to be a primary residence. It could just be a use that's more than an accessory use, right? Am I like a residential use, which I'm assuming could be either the owner using it for personal use or a year-round rental. That sounds like a residential use. And as long as that is more than the STR use, it sounds simple the way I say it. It can get a little more confusing than that. But isn't that basically what we're talking about?
In general terms that you're on the right track. Yeah, but I think obviously we would need to spell out when you cross that line.
And a bylaw could technically spell that out.
Yes.
Right. Okay. Thank you.
yeah. David,
Hi, and this might be a little off track, but I think a lot of the arguments we hear from people is commercial use, right? And in our zoning bylaw, in the definition of commercial use, it contemplates residential uses as being exempt. Is that right, Alex?
I believe that there's a provision that talks about a commercial accessory use potentially being allowable as accessory to a primary residential.
I mean, I'll look it up, but I think it just directly says other than nonprofit, religious, and or residential uses.
Yeah, I apologize. I don't know the answer to that.
No. So with that said, would a rental, if somebody rents their house and it's rented to a family and they're not using it for a wedding venue or something, they're using it to live in and vacation in, would that be considered a residential use?
Yes.
Okay. Thank you.
yeah. So I just want us to be careful not to be using this to try to get the answer to what is the current legal situation and all of that. I think, right, just to make sure that our goal here is to understand legal questions as they pertain to what this group can and should be moving forward. That was not a criticism, Dave, against your.
No, and that wasn't my intention at all, Stacy. I just wanted to kind of get that because as we go down this list, we continue to hear about commercial use. So I just wanted to make that definition, and it was certainly not aimed at any lawsuit or anything. I'm just trying to help everyone understand what the definitions are and how we need to deal with them. And maybe that's one that people were going to want to change. I don't know, but just that's a definition that exists and that we will have to deal with.
And does that exist in zoning or in
That's the definition, that's part of the definition of commercial use in zoning.
zoning, right? Because then we have to think about, okay, if the group wants to change it in general bylaws and not use a zoning bylaw, what does that do, right?
Right, I think, and my point earlier is, I think that when we create a zoning bylaw, that it needs to share the same language and definitions as the bylaw so that it sticks. We can't have a zoning bylaw and then a general bylaw that doesn't use the same definitions and language, because that will not hold up.
Yeah, agreed, Dave.
And just to be clear, right, one of the questions for this group, given just timing, right, is what can be done for this year's town meeting. And like, we know that the deadline to get a zoning article and move it forward is much earlier than the deadline to get a general bylaw moving forward. So it is super important for this group to understand what are there definitions that exist in the existing zoning bylaws that will limit this group's ability to move something forward for this year just using general bylaws. You know, so I think that's, Alex, something important to keep in mind as the group goes forward.
Sure.
Okay, let's take a couple more questions, and then I do want to try and move us on to Judy's presentation about zoning. I know it also gets a little bit into some of these questions about zoning versus general bylaws as well. But
And Stacy, just so everyone knows, I mean, following the meeting, if folks have additional questions, please forward them through Stacy, and John and I will respond to them.
yeah, terrific. Tom.
Thanks, Stacy. Good evening, Alex. A quick question. I was hoping you would give a brief overview of number 3, the Fifth Circuit case out of New Orleans and the Commerce Clause and all that. I thought that was a very interesting answer from the data meeting last Friday. And I'd just be interested to hear your thoughts on how that does or does not relate to our discussion here.
Sure, thanks. So the Fifth Circuit case out of, I think it was out of New Orleans, found that an STR regulation that treated folks who own properties who lived out of state differently from residents of New Orleans, that that regulation violated what's called the Dormant Commerce Clause of the U.S. Constitution. So the Commerce Clause prevents discriminating against interstate commerce. And I would note that the Fifth Circuit is known as being sort of a more conservative leaning court. So, whether or not the court's analysis there, where they found that, this regulation was unconstitutional and violates the Commerce Clause, I can't say for sure whether the First Circuit would interpret and apply the Commerce Clause the same way, assuming that, an eventual bylaw that Nantucket enacted made it all the way up to the federal First Circuit. But it is something to consider that, generally speaking, there are concerns about treating folks who own a property who live out of state differently from those who live in Massachusetts. So that's something to keep in mind. I can't predict how the First Circuit would treat it. There's a likelihood that they may treat it differently in some respects than the Fifth Circuit, just because of the sort of judicial ideologies involved. But it is an important issue to keep in mind, Tom. So thanks for that.
All right, Peter, Con.
Yeah, actually, my question was similar, and I wanted to follow up on that. Because I don't think it's simply a coin toss. When I'm a lawyer, and we're asked frequently to give our considered opinion as to the likelihood of something occurring, a court making a decision one way or the other. We're not asking for a prediction, but it's more than simply saying, well, they're different circuits and one's a little more conservative. I mean, I really think that we could take a look here, or you could, at some of the Commerce Clause decisions out of the First Circuit and the Supreme Court, and get some sense of what their thinking might be. And I commend you to I can send it to you. There's this came out. This Fifth Circuit decision came out in August. It's quite lengthy. It's quite well reasoned. And a law firm in the 10th Circuit, which was advising the town of Frisco in Colorado. Many of you may know that. It's near Breckenridge. It's a ski resort area, vacation area, in that sense, similar to Nantucket dealing with the STR. And there, the law firm suggested that this is an issue that the Fifth Circuit dealt with, and something that is well reasoned and likely to be something that they ought to consider, and guide them in their decision making. And they were much, so they didn't just simply step back from it. They took it on, and I really think that we deserve that. So I'd ask you and Joe and John to spend a little more time on that issue, because it's a critical issue for us. How are we going to treat seasonal ownership different than a year-round ownership?
Fair enough. Yeah, we're happy to dig deeper into that issue.
Thank you.
Yeah, and I would even say, because I don't clearly it is not this group is not the venue to decide the legality of such a thing. But to ask, if this group wants legal guidance from the town on how they should view this issue, I'm actually not sure. Would it be town council's call, and the select board and others would defer to town council, or how that even gets determined, so that this group doesn't try to put forward an approach that is inconsistent with, this group doesn't become the group that decides whether this should legally, they should legally be allowed to do this or not. So I just, to take that back to John and to the town administrator and the select board, to come back to this group with some guidance on. So maybe to, not discuss people's perceptions of this one way or the other further, but have that be something we get later, more input on, if that's okay.
Yeah, absolutely.
Okay. Julia, something else?
Well, it's on this exactly, but it's asking a question about, it seems to me like the case in Bourne may be like, and it has its own specificity. So I know more about Massachusetts than I know about the Bourne case, but in Massachusetts, there seem to be some other places, towns, like Brookline is one that I think is really simple, but they're talking about primary residences, and they make a distinction between primary residences and non-primary. Other towns look at owner occupied or non-owner occupied. As I understand it, these obviously would have been approved, if they're towns anyways, would have been approved by the AG. And I'm assuming that some terms lend themselves to less risk or liability maybe than others. Does that make sense?
Yes.
Okay, so then we'd have to just figure out from, you guys, like which terms to stay away from, or which terms to, maybe that have been tried and tested.
Yeah, absolutely. That's something we're happy to help with.
Great. Jim?
Thank you. Yeah, real quickly. Alex, I want to go from 3 to number 2 to connect the two if possible. Number 2 was a question I put forward through Stacy about commercial properties or business entities, it's called, in Palm Springs, California.
Mhm.
which defines who can and cannot rent STRs. And Palm Springs has come up with the view that a business entity cannot. They define that as something that is not a natural person, not a family, not a trust, and also not a limited liability corporation that has natural people. In other words, LLCs can rent out STRs in Palm Springs as long as they are identified with natural people, whatever that means. But my question to you is, if there's this New Orleans case that says if you're an out-of-state owner, you can still rent, let's say we agree with that, or we think that's going to be correct, which whatever, but let's say it is, would we still have the right to limit commercial groups or quote business entities from doing STRs despite that? Because I do think that may be a position that this group may want to consider.
So, the statute, chapter 64G, section 14, one of the sort of classes of types of ways you can regulate an operator of an STR is to regulate the class, right? So just based on the statute, the Massachusetts state statute, in my opinion, the group has the authority to limit the class of the operator.
In other words, class is I'm sorry to interrupt. In other words, class is something distinct from whether you live there or live somewhere else. Class is a whole different issue that can be regulated under that.
Well, not necessarily. So class could be, you could be talking about just within the state, or you could be talking in and out of the state. When you're talking within and outside of the state, that's when you get into the potential commerce clause issue.
I see.
So that's the distinction there. The federal commerce clause under the U.S. Constitution regulates interstate, not intrastate commerce. Does that make sense, Jim?
Yes, I think so. But I just want to bring the commercial enterprise or business entity back to our opening talk about what we love about Nantucket. And I just want to point out that I think many of us, all of us, maybe feel in our gut that people who own houses can love Nantucket and look out for the best of it. But a corporation, even if they're well run, even if they appoint someone to look out for problems, that a corporation cannot love Nantucket, cannot love a neighborhood the way people can. And that's why I think it's really important that we look at that issue.
Absolutely.
Thanks, Jim. Jeffrey, is there something you want to add? And then I think we're going to move on to Judy's presentation.
Yeah, so I live in New Orleans, so I want to give a little bit of context about that case. What it was about was in R1 zones, you had to have a homestead exemption in order to get a permit to do short-term renting. Now, you could become a bed and breakfast, you could do other things, there were more rules attached to that, and the people sued saying that that was unfair to them. Now, I'll point out all the people who sued live in Louisiana, so why this was a Commerce Clause case, that's neither here nor there. The ruling means that New Orleans is going back to the drawing board, and in the decision, the judge, amongst other things, actually suggested remedies to this homestead exemption issue. And what it means, maybe, and I can talk about this more in my section, is you end up with some more extreme possibilities. The primary residence was always billed as kind of this middle ground. And so the judge threw out some suggestions, including having an on-site operator who is a resident. It just doesn't have to be the owner. He talked about caps. He talked about a number of things that are still viable ways to regulate this issue. So it's not like it's a total free-for-all because of that decision, which I think has some other flaws into it. The city of New Orleans did not argue whether this was a primary or accessory use issue. It did not get into the reason why housing might be a priority over certain things. So I wouldn't frame it as now it's a total free-for-all. There are ways to get at, I think, some of the intentions of what that ordinance put in place. It still leaves a lot of possibilities. So I don't want people to get the impression of this could come to the First Circuit or the 10th Circuit or the Ninth Circuit or any of the circuits, and you just have to just throw away your ordinance. It is requires some shifting, but it still means there's a lot to regulate and a lot of ways to define who gets to do something and where they get to do it and when they get to do it. So that's all I wanted to add a little bit of nuance to that.
Yeah, great points, Jeff.
Okay, thank you. So as you heard from Alex, if there are additional legal questions people have, send them to me. And as we go on with our work, we will have Alex and John and his team all available to us to help us vet the different options that we are looking at and their legality. But with that, I want to pass this over to Judy Barrett, introduce her to all of you. Or Judy, I guess I'll give you a chance to just introduce yourself and share your presentation with the group.
Can you hear me?
Yes.
Super. So I know some of you and not all of you. I've worked with Nantucket on a number of things over, I guess, probably the last 7 years. And my role here is really to be available to your group and Stacy to help craft regulatory language. If you are able to agree on what you want the regulations to do. I have a small firm. I have 9 people working with me. Our office is in Hingham, Mass. We kind of work all over New England. I'm a planner. I've been in the field for about 35 years. And I will just assure you that you are, although perhaps in some ways uniquely affected by the short-term rental situation, it just seems to be an issue in almost every community we're working with, including Brookline. We're working on the Cape. It's there. It's just a big issue in a lot of places. So as I think you probably all know, you're not alone, but when it's your town, you feel like you're alone in a way. So I just was asked to do a little bit of an overview about zoning and kind of Nantucket zoning. Some of what I say in the later slides here will kind of echo what Alex just talked about, although not as articulately as he did. And then I can, answer some questions if you like. So I think with that, Stacy, I might just start my slides.
Yeah.
And I assume I have screen share permission.
Be able to do that. Yeah.
Very good. So let me get this going. Can you all see that?
Yep.
Okay.
Perfect.
So I just, again, was, asked by the select board and the town manager to be available to you to help craft regulatory language. I should point out that my firm basically works in 3 primary areas. One is comprehensive planning, downtown planning. We just do a lot of area planning and town-wide planning and citywide planning as well. I do a lot of work in affordable housing. It's a topic that's near and dear to me. And the other thing that we do, probably half or more of our workload in any given year, is zoning. So that is also a topic that's near and dear to me. So I want to just sort of do a little bit of an overview, touching on some of what you already know and have already discussed on zoning and non-zoning methods, and why sort of each one has some particular advantages. And then tell you kind of what we need to know as consultants in order to be able to draft something that you can then review, comment on, go to town council, who will, certainly perhaps, change some of what we say or make it better. So there is a process here to actually getting regulatory language perfected in a manner that allows it to go on the town meeting warrant. So your town code, if some of you may be very familiar with it, I don't know how many of you have actually studied this particular bylaw, but your whole code is on the E-code platform, which is pretty good. Your bylaws are kind of organized into 3 different sections. You have administrative bylaws, you have general bylaws, you have the zoning bylaw, and then you have all your kind of administrative regulations are also on E-code. So pretty much the way the town governs itself and who does what is all pretty readily available. And I think for the most part, what is there is pretty up to date. So zoning is, in Massachusetts is kind of a little bit different from some states in that we are a so-called home rule state. So a lot of what you find in zoning bylaws and ordinances in Massachusetts is really quite different from community to community. The Zoning Act, which is kind of what we all operate under, is not really a prescriptive list of what you can and can't do in terms of land use. It does kind of bar you from acting in certain areas, but it mainly lays out kind of the procedures for doing what you want to do. So in zoning, you're typically trying to regulate land use. So it's the use of land, buildings and structures. Your town divides your community into 25 use districts as I last counted. And why do we have different use districts? It's because the town wants to allow different things to different levels of intensity in different parts of town. And going back to an earlier master plan, which I think was a pretty thoughtful document, the idea of dividing Nantucket into these sort of overall two buckets of a town area, which is where the most kind of activity center of the town would occur, where development might be encouraged, redevelopment might be encouraged, activity centers. And then the rest of the island being in this sort of country framework, which is the more rural and undeveloped areas. So within those sort of two buckets, you have a variety of zoning districts. There are also special districts relating to certain types of purposes, such as environmental protection. It is somewhat of an unusual zoning scheme compared to a lot of other towns, but it kind of makes sense in Nantucket. And whenever I get there and I sort of walk around, I kind of understand why the town is divided into the districts that it is. Nonetheless, it is a somewhat complicated bylaw relative to many other communities I've worked in. What I will say is that I think the overall framework of it is substantially consistent with your town's master plan, which is a good thing and not always true in Massachusetts communities. What your bylaw says about the town overlay is that you're trying to limit to a certain part of town areas where there is already infrastructure, where if the infrastructure needed to be extended, it could be done without tremendous expense. Areas where kind of producing housing affordable for year-round residents would be encouraged, if not kind of heavily incentivized. And that it's an area with development patterns that are sort of conducive to pedestrian activity, not necessarily requiring a car to sort of get all over the place. So I think if you think about the town overlay as areas of the community where the town wants to encourage a lot of activity, that's what it is. And the country overlay is simply kind of the opposite. It's to discourage development and preserve parts of the island that are sort of traditional or historic and kind of rural in nature, and also to sort of discourage the spread of a lot of development that would promote auto-dependent use. So this map kind of shows you in green what the town has said. This is sort of these are the areas of town where we think we want to concentrate activity in Nantucket. It doesn't mean that no activity is allowed anywhere else, but it means relatively more intensive development, intensive land use patterns are encouraged and allowed in these areas that are depicted in green. And just to zoom out, this map of the entire island, I think, gives you a pretty good picture of what it means to have 25 odd zoning districts applying to different parts of your community. But again, I think the reason that Nantucket has chosen this approach is to be kind of very specific and intentional as to where greater or lesser amounts of activity will be encouraged. And that, of course, is what a zoning bylaw does. And it does it through mapped zoning districts, which I know you can't read this. You don't have to read it. I just am putting this in front of you because I want you to know that this could be your best friend as the short-term rental working group, because what this is the table of uses from your bylaw. So that map I just showed you with all those different colors, those are all the different districts in Nantucket, and every one of them resides in some way in this table of uses. This is where if someone owns a piece of property in the R1 district in the town overlay, I'm going to go and see what I can do with my property. So if you're trying to regulate something like short-term rentals on a district basis, which is probably the easiest way to do it, this is the chart into which you would go to add a Y if you want to allow it as of right in certain areas, or a special permit, which is the SP designation you see here, or simply an N, meaning no. So in some areas you would say, yeah, short-term rentals are okay here. They're not okay over here, and they might be okay in some other area, and that's where we're going to allow the discretion of a special permit. All of that resides in this table, and it's just a critically important part of the zoning bylaw. And you can regulate both principal uses in this chart as well as accessory uses. You know, just thinking about kind of what does zoning do that's different from a general bylaw, it's about controlling the use of real property, which is not the same as sort of an operation of an activity, which is what the general bylaw gets at. Uses are permitted kind of either as of right or by special permit, as I said, or prohibited, which is what that table of uses that I just showed you does. But you can, and many towns do, put certain conditions on even uses that are so-called permitted as of right. Yeah, you can do this if, so for example, with short-term rentals, you might say, well, you know, they're permitted only on a seasonal basis, or the structure has to be owner occupied, meaning it's the property owner's principal residence, notwithstanding that very interesting case from New Orleans. You know, how often can a unit be occupied for short-term rental purposes? You know, the unit to be legal as a zoning use also has to comply with the registration bylaw. Is it principal? Is it accessory? And then aspects of the impact of an STR, such as the amount of off-street parking that may be required. Are you going to allow any kind of signage? Are there any kind of lighting restrictions? Things that might affect the way the short-term rental has an impact on surrounding properties. So these are the kinds of things that you could, if you chose, regulate through zoning to ensure that there is some reasonable mitigation of a use on surrounding properties. As I think you all know, the Attorney General has approved Article 39, which is really helpful because there is a definition in Article 39 that I think, as Alex said, and maybe one of your committee members also noted, you really don't want to have two different definitions. So you have one to work with at this point, which I think is helpful. I'm not suggesting that you have to use it, but it's there and it seems to make sense. With zoning, as Alex and others have mentioned, there are some timing issues involved. So one of the features of the Zoning Act in Section 5 of Chapter 48 is the Zoning Act. If you're going to go to zoning with a town meeting with a zoning change, the planning board has to have a pre-town meeting public hearing. And they're supposed to give a report to town meeting as to whatever came out of that public hearing. So there's a timing consideration. Before you can get to town meeting, that public hearing has to take place. So it's not just simply when is an article due with the select board office, it's also when does the planning board need to hold that hearing in enough time that if they wanted to make some changes to the proposed zoning, they could do it in time before the warrant closes or before the warrant is published. Zoning is always kind of a prospective sort of regulation. It sort of applies from this point forward. As you've all talked about, you know, there are certain kinds of uses that are protected if they were lawfully pre-existing. I won't go there on this whole argument in Nantucket. I realize there are differences of opinion on that point. I so understand the town's official position, or at least that of the building inspector, is it's a lawfully pre-existing non-conforming use. So until that's changed, that's sort of what we're dealing with. It can be difficult to secure zoning amendments at town meeting. It takes a 2/3 vote, except for certain types of residential uses, such as multifamily housing, which can be adopted on a simple majority basis. Most zoning requires a 2/3 vote, and that can be hard. You know, and the only other thing I would say is if you're thinking about the position of the property owner who may be operating a perfectly lawful and quiet short-term rental, you know, a permitted use of one so-called as of right is more security to the property owner, I think, than the relative or seeming risk of a special permit, which does require one to go before a board. Typically, it would have to be the planning board, the zoning board of appeals, or the select board, depending upon what your bylaw says. And that is subject to a public hearing and a butter notice. And abutters may choose to, or any interested party may choose to appeal. It's a little more secure if it's a permitted use. Those are policy decisions, obviously, but I just sort of want to make you aware of that. You know, non-zoning, as you know, is the general bylaw approach. It's when it passes, that's it. And there's no such thing as a vested right. There's no requirement to hold a public hearing before town meeting, although many towns do that just so people know what's going on. It is a simple majority vote. And of course, it can be paired with amendments to the zoning bylaw, which is sort of what you would be doing if you decided to allow short-term rentals in some districts and not others, or allow them in a more liberal way in some districts than others. You know, you would always still be sort of paired back to that general bylaw that you've already passed that requires registration. So these are just kind of, you know, which tool do we use? Well, it sort of depends on where you are in the process and what you're trying to accomplish. Your town certainly has plenty of general bylaws now, in addition to Article 39. If you ever took a look at the E-code version of your bylaws, you'd find some very interesting things there, such as maintaining peace and good order. We still find a lot of these things, these sort of older bylaws in communities that have never been changed, but your whole housing needs covenant program is a function of your general bylaws. You have general bylaws that address the issue of right to farm, as many communities do. You have a local wetlands bylaw that is a general bylaw that empowers the Conservation Commission to exercise a reach of jurisdiction with wetlands protection that kind of goes beyond what the State Wetlands Act does. So you have a lot of general bylaw tools already in your community, certainly having Article 39 and perhaps some other general bylaw to accompany it would not be, would not be out of line with the way you already kind of act as a community. There's a lot of things that you can regulate in the non-zoning approach. They're kind of listed here. You already talked about the New Orleans case. I won't belabor that point. But either way, you get types of control. It's a question of what you're trying to regulate. If you're trying to regulate the land use, it's a zoning question. If you're trying to regulate the operation of something, it's, if you think about it more from a non-zoning or rather a general bylaw perspective. Both of them are kind of functions of home rule. There are things that these kind of both have in common rather. Home rule does have limits. If it's an area of law that the state has asserted primary jurisdiction, you can't overcome that. But certainly so far, short-term rentals don't seem to be in that class of sort of state preclusion. They are both subject to certain statutory procedures for adoption. The procedures are different. So while you have tremendous latitude as a community to decide from a policy perspective what you want to do, you still have to follow the procedures in law to adopt your bylaw. They're just different procedures, because zoning has certain requirements. General bylaw, as we already kind of understand, is a little bit easier, but nonetheless subject to general laws for procedures. Both subject violations to certain caps on fines. The fines are fairly low. In the Attorney General's approval of Article 39, a much higher fine was upheld because there didn't seem to be any limitation placed on it in the state law governing short-term rentals. So that was kind of interesting. And I guess I just want to sort of point out here, this is worth a pause from my point of view. I think Julie had mentioned correctly, there are a number of towns that are doing things with zoning and so forth that the Attorney General is approving. But it's always a good idea to go and read what the Attorney General said in reviewing bylaws from communities, because often the Attorney General's office will raise concerns that may not rise to the level of rejecting a bylaw that has been passed, but nonetheless putting the community on notice that there may be issues that could arise in the execution of a particular bylaw. It's just not at all uncommon to find sort of notes of caution. I'm sure Alex can probably tell you all kinds of war stories about things that the Attorney General has said, yeah, we're going to approve it, but just so you know, you may have a problem with this or that down the road. So simply something being approved by the Attorney General's office doesn't mean everything is fine. It just means that based on what's understood with current case law, judicial decisions and statute, it looks like you're okay, but you could have a problem, and here's why. So those decisions from the AG are really, really helpful to read. For us to be able to help you, which we really would like to do, we have to know what you want to do. It's the most important thing to me, and just understanding what you want to do, especially if you want to get something for town meeting next year, because there's not a lot of time to do a lot of redrafting. So we want to understand kind of what are you trying to accomplish here, because different objectives may sort of drive you more towards zoning or a general bylaw or some combination of the two. You know, are there, you know, I think something I often talk to towns about when they're considering bylaw changes is whether there is adequate are you concerned about enforcement capacity? I mean, when does that become an issue? In some communities, they don't really care. It's sort of, if there's a problem, then enforcement will work, and otherwise we're not asking a building department to go around and be police. But, you know, just understanding that enforcement capacity can be an issue. And I always bring up with any of the towns I work in on any kind of zoning, don't forget to look at something from a racial equity perspective. Sometimes zoning has, you know, racial implications for some groups over others, and it's important to at least think about that when you're deciding what steps you want to take to regulate a particular public policy objective. The only other thing I would say is whatever you want to do, the more you can keep it simple, which I realize may seem a little bit daunting, but the more you can keep the regulatory approach simple, the more likely it is that you're going to have fewer problems, because the rules will be clear and people will know where they stand, and the building inspector will know, you know, what to enforce and what is actually okay, and there won't be so much ambiguity. So keeping it simple and keeping it clear is kind of always the objective of anybody writing. I don't care if it's zoning or a general bylaw, it's just trying to keep it simple as much as you can. You know, these are just kind of examples of things that we would want to know in trying to help you to craft something to take to town meeting that will accomplish what you think is appropriate for Nantucket, is something that can be upheld, is something, you know, something that sort of works within the bounds of law, and is capable of being implemented. You know, and the only other thing I would say is if you're sort of at this point where a lot of things you sort of have agreement about and some things you don't, if there are ways to kind of understand where people kind of voting in the minority on something might stand, sometimes there are ways to address so-called minority positions without, you know, but while still sort of allowing the perspective of the majority of the group to be able to advance what their perspective is, but at the same time be able to perhaps build in some protections that would better address concerns of a minority position. That's another thing we try to sort of think about in writing zoning is, you know, how can we accomplish as much as we can here and accommodate as many interests and concerns as we can, and still keep this thing simple and enforceable and capable of being administered. You know, I think this is kind of something to consider. It's sort of open for discussion, I guess. You know, zoning is often kind of an easy option, even though it has certain barriers associated with it, the time with the planning board public hearing and so forth, because that zoning chart I showed you earlier is a very tempting thing to be able to simply go in and add a line, short-term rentals as defined in this bylaw. It's a Y here, it's a Y here, it's an N, it's an SP, whatever. At least at that point, you know, you're then able to kind of say there are parts of town where this is okay and parts of town where it probably doesn't make sense. Now, you just have to understand that when you pick those quote parts of town, you are bound by the boundaries of a zoning district. So you're not going into individual neighborhoods and saying, well, this place is okay and this other one is not. It's, you have to work within the zoning districts as they exist. You know, a general bylaw, I think, can get you where you probably may want to go. It's easy to enact, avoids a lot of scheduling problems, and it could pair well with your existing Article 39. So I almost think in some ways, you know, you're okay no matter how you do this, but I think the optimum would be pairing a zoning bylaw with the general bylaw approach is probably going to get you the best outcome. So that's kind of what I have to say at this point, and I'm happy to answer any questions. I can keep this up to go back to a slide, or I can take the presentation down.
Why don't you take it down for now, Judy?
That's fine. I'd
Yeah,
much
so
prefer
we
to see
can-
people.
Yeah, so we can look at each other and then
Yeah.
we'll pull it back up if needed.
That's fine.
David. You're muted. There you go.
Couple questions if I could for Judy, to you, Stacy. Glad to see you, Judy. Happy you're part of this.
Thank you. Nice to see you too.
Can you explain to us if this group decided in some way to restrict the amount of STRs in a zoning district by percentage of units, what that would look like as far as a use chart or a zoning bylaw married with, I see her cringing. And if that's even possible.
I think you would be better off to consider an approach like a minimum distance between short-term rental uses. Your question raises an immediate question for me, which is, what's the source of data you're going to use to determine how many residential units are in a district? Is it going to be the assessor's records? Is it going to be census data? What's going to determine the number of units in that district, if you're going to then operate on a percentage basis?
Okay.
So I think you may be better off thinking about things like a minimum separation. I think that in some ways maybe is a little easier to work with.
Yeah, my concern just with that, and again, this is just me thinking out loud. My
Sure,
only
sure.
concern with that is at some sense, if we limited percentage, it would protect people that are participating in that use now. And if we did space between units, that would preclude people. So I'm just throwing it out there because I think it's something that we as a group should maybe look at some level in some zoning districts. So that one just out there to think about. The other one could you give us an example on how we would marry a use chart change to a restriction by a bylaw that would restrict in some sense?
Well, you have a registration bylaw now. If you were going to amend your zoning and stay kind of within the confines of zoning, you could amend your zoning bylaw to add a definition for short-term rental, which would marry what's in Article 39 now. You would go into the use table and say, these are the districts within which short-term rentals will be regulated in one way or another. Yes, no, or special permit. You may in fact have a section on special regulations for short-term rentals, where you might get into more detail about what does it mean to be a permitted use for this particular category of use.
And that would live in the zoning chart?
Yeah, no. You
That
would
would
have
live
it
in
in
the
your bylaw,
in the
a
bylaw, yeah.
section of the bylaw for special regulations.
Okay.
That's not uncommon at all. I mean, we think about home occupations is a good example. You know, home occupation shows up in a table of uses as permitted, you know, in multiple districts. But then there's a special regulation section that says a home occupation is permitted if, and you list the conditions under which it's permitted. So that is one kind of approach you could take. You know, if you were saying in your bylaw, your zoning bylaw, it's a permitted use in the following districts. And one of the conditions is subject to compliance with, you know, all other applicable bylaws of the town. Now, on the general bylaw side, you have both a registration, but then also perhaps some other conditions that you're imposing on the activity or the operation of a short-term rental, as opposed to regulating the use.
And that could be targeted in the use chart by zoning districts.
Yes, if you were, yeah. I mean, certainly that would be the way you would do it. You would want to make sure that the use chart tells you, if I were the building inspector, I'd want to know, is it a lot across the board? Is it only allowed in certain districts? just make it clear.
Yeah,
Um,
no, and
yeah.
tie it in with the definitions, the use chart, and then the bylaw for regulations, right?
mhm, mhm.
Last question, I'm sorry.
That's all right. I'm fine. It's up to Stacy, but
So as you know, this group was kind of put together originally to debate or to figure out what we were going to do with 42 and 43.
Yeah.
And I guess this is just a question as to best use of time and those two articles. And I've been putting a lot of thought into this, and I'm just wondering, and I guess your opinion would be helpful, I think, for the group and for myself, is if we decided to just sit down and take those two articles and as a group decide on what we accept and like and what we don't, and take the parts we accepted like and start trying to formulate something. I mean, because we
you
need
certainly
to,
could do that.
but zoning is the place we should start, is I guess my question.
Well, if there are area related, if there are concerns about the operation of short-term rentals that are area related, geographically related, I think you have to go to zoning. Because you may want to be more liberal in your allowance for short-term rentals in some places than others.
Yeah.
And if that's the case, then you gotta look at the zoning bylaw. But how much of the sort of special regulation or conditions on the operation belong in our land use question versus just regulating an activity or an operation?
Yeah.
I would try to put them in those two buckets and then think through, does this belong in a general bylaw or a zoning bylaw?
Yeah, land use is gonna end up in a zoning while regulations is gonna be, is that what you're trying to say?
And
Regulation.
then I'd probably call town council and say, this is what I think.
Yeah,
What do
no,
you think?
I'm just picking your brain and I'm
yeah.
sorry, and I don't mean to waste group time. Thank you.
No, it's okay.
Julia?
Thank you, Judy. This was really helpful.
Hi, Julia.
So I think I just got clarity on something in the last answer. What I heard is, for example, a general bylaw would have to apply to the whole island. Let's say defining a class of operator or number of days or whatever the tool is. Let's say, for example, instead, the decision was we wanted to, and I guess it all goes back to what you said was the most important step, maybe is to define what we want to accomplish, which is really maybe the precursor to this whole discussion of actual tools. But let's say, for example, that we had that discussion and we said, we want to allow commercial, primary use of STR or STRs, no other, no residential use in commercial districts, which sounds pretty reasonable, if you ask me, because that's where the businesses are. That again, versus a residential zoning, that again would be zoning related. You couldn't necessarily accomplish the same thing through a general bylaw. Am I understanding that correctly?
That's how I see it. Yes. I mean, if it's really kind of geography specific, it belongs in zoning.
Mm-hmm.
If it has to do with how the use is operated in some way, noise, occupancy standards or something like that I would probably put in a general bylaw. And so now if I'm thinking, what can I do? I own a piece of property in this district. I'm allowed to do it, but I still have to comply with all other bylaws of the town. So I have to get registered. There's an occupancy limit on the space that I'm making available. I have noise and nuisance, restrictions that I have to deal with. The things that sort of determine how I operate that use, in my opinion, would be better served in the general bylaw, but the geography of where is uniquely the province of zoning. And there may be some aspects of special regulation that belongs in zoning too. And I'm not trying to muddy the waters here. I'm just saying you'd almost look at what's all the stuff you want to accomplish. And then I would probably create a chart with two columns. Here's what they want to do, zoning or general, and just start kind of creating sort of a patchwork.
And we're not necessarily in a position to decide where it lies. That's kind of that's the experts. But I guess this question may be for Stacy. I'm excited to have that discussion about what are we trying to accomplish? Because when people try to talk about what this community did or what that community did, I'm like, you know what? It doesn't even matter. I mean, it does, because you can understand like maybe some of what the landscape looks like, but what do you want Nantucket to look like? That's the question. So are we having that discussion at the work group level at some point to be able to start parsing out the options?
Yes, so our next discussion as we shift over to Jeffrey is to talk about what are all the different tools and mechanisms that could be used. I think we have to accept that not everybody agrees on exactly what it is you all are trying to do. So part of what you're trying to do is find a middle ground that is an acceptable package for everyone. And so, I mean, we could just sit around and talk about what our goal is forever. And I don't think that would necessarily get us directly to where we want to go. I think there are some places where the group's going to be able to agree pretty quickly. Yes, we want to do this. So yes, we're going to get to that. We're going to start doing that, but we want to do it in the context of an understanding of these basic things, how zoning is, what legal mechanisms there aren't, some of the tools available. And as we've heard from the beginning, what information we already have about the STRs as they exist and the impacts that they are having on Nantucket, to the extent we can get that information that, to help us guide that conversation forward.
So we'll come back to this. We'll set aside kind of what we've learned and then come back to, okay, what can we all agree on is like, okay, that is great.
Absolutely. Kathy.
Okay, just to train of thought here. So we know that 39 exists. We know we have regulations in place. We've already defined them, and they address noise issues, nuisance issues, safety issues. We'll be able to get a good count of how many operators there are and how they use their space, which is something we don't really have right now. So in some ways, I think, let's see what that does. Does that solve some of the problems that people have out there? If there's a perception or real or not real about noise, let's see how that plays out, perhaps. Also, I think that there's been, at least some people I've seen in the papers and so forth, have been reluctant to call the police when there's a noise issue, because they're worried that their neighbor won't like them, or they don't want to bother the police. But really, unless you tell the police, they can't enforce it. So it's a self-perpetuating thing. So I was just sort of thinking along those lines. The only protection, or the only thing that we haven't addressed, and that's because 42 and 43 were remanded to this group, is zoning, because right now we have that lack of clarity there. We have lawsuits in place. And so to me, there is no way, unless you can say something other than that, Judy, to stop these lawsuits without some kind of zoning definitions that makes it very clear what Nantucket will allow. And then the question is that retroactive, or are you still in violation? Does that still go to court because that wasn't clear when the person filed the complaint? That kind of thing. So I just wonder if that's really, we have to do zoning. And then maybe we want to add some more things to 39, yet maybe we don't. Maybe we see how it plays out, but protect people's from being sued. Is there a way to do that other than zoning, or does it have to be zoning?
So, this question I think still echoes for all of you, which is, and please correct me if I'm wrong, that the building department or the zoning enforcement officer's official position is that a short-term rental in Nantucket's context is a lawfully pre-existing non-conforming use as an accessory use, because, quote, people have been doing it forever. That's my understanding.
Just one quick correction, Judy.
Sure.
I believe he interprets it as an allowable use, not pre-existing non-conforming, but that it's an allowed accessory.
Allowed now, excuse me,
Right.
of course. So if we change the zoning, the question is, would someone who was considered allowed now, do they become a vested right? And I think through zoning, they do.
Right.
I don't know how through zoning you sort of take away a right that section 6 of 48 clearly says that you have.
Okay.
So that to me is really a question. Frankly, I would bump that to town council.
Yeah. No, you're spot on, Judy. It's pre-existing non-conforming rights are statutory from 48
Yeah.
section 6, so we can't erase those through a bylaw amendment.
That's kind of what I thought, but I'll leave it to you to say that. How's that?
Fair enough.
Okay. Kathy, were you done?
Yeah, I guess I am for now. And I go back with what Julia said, we have to still define the problems that we're trying to solve, because we
Right.
haven't done that. We have to circle around to that. And I think there probably is a lot of places that we can agree on things that we would like to prevent happening in the future, even if they haven't happened now, and discuss what what the problems really they are, and to what extent it's a short-term rental that's causing that problem. Because even if it is associated with it, what percentage, what's the impact of it? And also, what's the impact of putting in a regulation? So some of these things I think would be very useful to know. Well, what this town did is X. If we do X 10 years later, what does it look like? Does it look like what we think it's going to look like, or does it look like something different? And that's the scary part, is the unintended consequences of what we do. Thank you.
John.
Judy, this has been really an eye-opener and educational, so thank you so much. Actually, my question is a little bit broader, and it's more of a, do you have a point of view on something more than a question? The thing that I have, I'm starting to wonder about is, we often have difficulty in drawing a line from a problem on the island and SDRs, to what degree do they impact them or not? And I'm coming at this for your point of view on, just the affordable housing part of this. And I don't mean affordable housing, subsidized. I mean people that want to have a normal job, whether it's a nurse or a teacher, or to live on the island and live where they work. And I saw in Nantucket Current this morning, the entry level sort of average or mean house price now is $2 million. So the question, or what I'd like to get your opinion on is, okay, if that's really $2 million, if that's it, there's seasonal homes that people own and they rent them for everything we're talking about. And then there are other seasonal ownership, which people just own them and they use them when they want to use them, and they remain empty when they don't want to use them. Do you have a point of view on whether there's any change in the balance between seasonal residents owning and renting, short-term renting, versus seasonal residents that are just buying them and they use them when they want and they lock the door and leave when they don't? Do you have any thoughts on that?
Well, whether they're only using them intermittently and then locking the door when they're gone, or using them intermittently and otherwise renting it out for short-term rental purposes, what the unit is not doing is providing housing that's
Yes.
permanent. And so, I often do think about this, because I got asked this a lot, what's the affordable housing impact? And I'm not going to go there, because I know that there are people, I'm looking at you, and you have different opinions on this, and we could probably spend the whole night on it. But I will say, of the various housing studies that have been done in Nantucket over the years, the one that I often think about goes back to the very early 2000s, probably 2001, when John Ryan, a consultant I know well, made the observation that you have too many markets competing for the same inadequate supply. And that is really what's driving the affordable housing challenge for Nantucket. And that was 2001. And in many ways, I think that is still kind of your overarching challenge, is a lot of markets competing for the same inadequate supply. And what you have today is kind of a different market mix, because the short-term rental has become such a factor. So, that's sort of a market presence that may have always been there, but the question is, was it there to the degree that it is now? And, I don't have the answer to that question. I'm just saying that when you have multiple markets competing for a certain supply and the supply is inadequate to meet all those demands, you're going to see an affordable housing impact. And I think
Okay.
that the short-term rental is just one piece of that.
Yeah, and that's the bit I struggle with, that it's a piece of it, but it's not all of it. So, but thank you for that. Thank you.
Thanks. Jim.
Thanks for bringing that up, John. I want to agree that we don't know the effect of short-term rental on all that, but we can sort of intuit, as I think Judy was saying, and Judy, your presentation has been great, but if you take out some of the short-term rental presence, perhaps that will help. Now, maybe almost all those houses would go to seasonal houses and not help with the year-round supply, but I suspect some of them would go to year-round supply, which would help. And Judy, just a really quick question. Great presentation on general bylaws versus zoning, but if there were regulations about what I think Alex called class, which is who is allowed to do short-term rentals, such as, I'll just bring up again, business entities. I'm not stuck on that, but that's just one example. Would that and could that exist in the zoning, sort of check off of yes, no, SP, or would that be more a general bylaw that would sort of overarch all the zoning districts or most of them?
Well, I think I would probably do that in a general bylaw, but if the definition of a short-term rental is a unit in a residence that is owner occupied as the owner's principal residence, by definition, it's a residential use. Because the owner has to live there as a principal residence. I mean, it just depends on how you define it.
Right. Yeah, that's absolutely right. Okay, thank you.
You're welcome.
David? And then I want to move us on to Jeffrey's presentation. You're muted, David. David, you're muted.
Through you, Stacy, to either Judy or Jeffrey, are you guys familiar with a report done, I think it was done in the San Juan Islands, I think in 2020, that researched STRs, affordable housing, all those kind of things, and it actually pulled some Nantucket information into it. Have you guys seen that by chance?
I have. San Juan Islands is actually an example in my presentation I'm about to give as a decent analog. There have been a variety of studies, again, how applicable they are. I think Judy really made a really excellent point of understanding that mix of competing marketplaces is very, 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 very difficult. If I could do that quickly, I would have a doctor in front of my name and be touring the lecture circuit. It's really, really difficult to do. And so sometimes it's tricky to kind of compare the housing market side of things, even if the regulations, which I'll show you what the regulations are, or the framework of it, can be very, very similar. So you often have these very niche studies that have been done. I know there's a great one from Georgia State on the SEC football schools and the effects of sort of that kind of alumni money that comes in and buys game day houses. The San Juan Islands is a decent analog, but again, it can be hard to kind of replicate even their methodology sometimes in other contexts.
No, I mean, I think part of the reason is just, I think Judy's quote about that. I think that just competing housing markets is an important thought. But I'll forward this to Stacy, and if she thinks it's appropriate, she can forward it to the rest of the group to read. Thank you.
Stacy, can I make one more comment before
Yeah,
I
go ahead,
close?
Judy. Yeah.
This may not bring any comfort to all of you, but I think if you go and look at the history of zoning amendments in Nantucket, you will find that the town has amended its zoning bylaw many, many times. And you may make a decision now to take some amendments to town meeting and they pass. And you have some experience with them, and 2 years down the road, you say, this isn't working as well as we thought. you can always amend your bylaw again. I had a conversation with a colleague on my way home tonight, where they're thinking about amending their inclusionary zoning bylaw, the bylaw that for sort of mix of affordable housing in all market, otherwise market developments. They're looking at third time in 12 years, they're looking now at, is this doing really what we wanted it to do? It's doing some things, but it's not doing this as well as we would like. So they're looking at potentially another amendment. That's the beauty of being a community that kind of thinks, thinks about its regulatory framework and thinks about whether its regulations are really meeting its policy objectives. You can change your regulations if they're not doing for you what you thought they were going to do. So don't assume that whatever decisions you all make between now and January or March or a year from now are going to determine the fate of Nantucket forever, because it's just not true.
Thanks, Judy.
You're welcome.
Peter.
And just quick, first off, John, I think that the average house now is about 3.2 million, unfortunately. Number two is, if we're looking here to solve, we've talked about this before, to solve the affordable housing problem, we're in the wrong ballpark here. There's a lot of other places that we should be looking that could, truly impact housing. I'm talking about 150 units at one time, something like that, which is a whole different discussion. I'm not advocating anything, but this should not be our goal. And lastly is something that I think Julia brought up last time is, and this is something we have to consider. If you have two houses next to each other, this one's allowed to rent and this one isn't, the one that's allowed to rent is worth 25% more than the one that it isn't. I mean, to me, that opens a whole nother can of worms.
Okay.
I'm done.
Yeah, so we're getting a little more into discussion on what we want to see happen, which is great, but I just want to hold it for now because I'd like to let Jeffrey present. So John, is that okay? Okay, so let's turn this over to Jeffrey. And with thanks, many thanks to Judy.
Yeah, thanks everyone. I see everyone's wheels turning in their little boxes, which is always good to see. So very briefly, in case anyone missed, I'm Jeffrey Goodman. I'm a certified planner based in New Orleans, beautiful New Orleans, where it was 85 degrees today. And I'm brought on to talk a little bit about data, which I talked about last time. And this is really more about planning. And this is just a way, I think, piggybacking on Judy's presentation, we've gotten some of the frameworks of how things can be expressed through regulation. I want to get into a little bit about how to even sort of, as you think about all the different ways to go, how do you organize that into, again, a kind of convenient structure that you can fill out on a sheet and be able to compare notes with people or be able to kind of make sense of a lot of ideas that are swirling. Again, Granicus is the data partner on this. So sort of speaking to what she was saying is that we have to understand that this issue is a lot of spectra, which is, we can view this, and I think I've showed this little graphic before, as part of a spectrum of lodging types, right? From a couch one day a year to a resort. You can really cut a lot of different lanes within that kind of spectra. There's also a lot of different kinds of users and uses that we call short-term rentals within platforms or within some of these real estate sites. It's a catch-all term. It's not a specific term at all. And we have to define, I think, or give shape to it as it relates to Nantucket. And then another way to think about this, maybe flipping how we think about this, is to understand a spectrum of impacts. So there are impacts on housing availability and affordability. There are impacts on the tourism economy, on neighborhoods, on the taxes and budget, on even something like sustainability. There are spectra. I'll make my Latin teacher proud. There are spectra of these, and we need to be able to understand, even on the impact side, what are bigger impacts, smaller impacts, acceptable impacts, not acceptable impacts, in order to get a handle on how any of the choices we make are going to shift both, say, the housing market, but also broader structures that we're concerned with. So I did a very simple structure in terms of how to think about these levers within planning. And it's who, what, when, where, how, and then why. And the first one is really who can operate a short-term rental. I think we've been circling this certainly for a few meetings and certainly this meeting today. And that's going to be one of the most powerful tools to shaping the short-term rental industry in general. A very, very common one would be a principal residency requirement. I think we get at an important question, which is how do you find principal and how do you define residency? Lots of places do it in different ways. Sometimes that has to be tailored to the realities on the ground. Nantucket has a slightly more complicated residency pattern than, you know, some random town in Massachusetts. So you don't want to necessarily map some other towns, you know, very suburban style residency onto Nantucket. It's just not going to work. You're going to have a lot of conflict points. A big thing is in-person operator. This is probably how New Orleans is going to get around their Fifth Circuit ruling, is to require that there'll be a resident. It doesn't have to be the owner, but an in-person operator. That would make it hosted. So you have unhosted and hosted. Hosted means that there is an operator, usually the owner, on site during that that short-term renting. I do want to bring up, and this comes out of Florida, something that triggers whether a property needs to be registered at all is whether it is advertised for the general public. Properties that are kept internal to, say, your friends and family, however you want to define your friends and family. If there's no public offering of it in Florida, it's more complicated, but in Florida, that wouldn't automatically become a short-term rental, whereas something that does get advertised immediately needs to be registered. It immediately needs to follow all the other rules. Some places do a separate property management license. They try to break up the operators from, say, the owners, where if there is a management company that they have to be involved in regulation, often around issues of quality of life. As we've talked about, a natural person license holder, so a human gets this license as opposed to an LLC or even a trust. And then very important, related to back to zoning, is whether something is going to run with the land or run with the license holder. Often that is something that trips up a lot of places, is that they think they're going to have something run with the license holder, and because it's, say, a zoning change, it's going to run with the land, and it's going to be harder to sort of backfill that later. And then I do want to talk about capping schemes. So a basic cap would be just simply a number. And then beyond that would be a waiting list, maybe a lottery, to determine when someone leaves the industry, the next person up in that waiting list joins. Other places, and we'll talk about this with San Juan Islands, do what's called a moratorium and attrition, which is they have a goal to reduce the number of short-term rentals over time. And so you end new permits. And so when people leave the industry, there's simply no one to fill them. And so the number of registered short-term rentals go down over time. Other places have talked about this. I don't think it's actually been implemented. There's often state law making this difficult, but some places have talked about say a taxi medallion system, which is there is a secondary market for permits that allows for investing and trading and all these other things, partially to try to align the value of the permit with the value that people expect from having a permit. It's an interesting one, and I throw it in there, but it is often an option, although I don't know that's true in Massachusetts. Next up would be what? So what can be a short-term rental? So we certainly see a lot of places do things by whether there's an operator, whether it's hosted or unhosted. We see a lot of places do things by whole or partial home. So home meanings you have full access to the entire unit and there's no one else there. Partial would be a bedroom. Often it is, say, even something that wouldn't qualify as a separate apartment because it doesn't have, say, a kitchen. You can also sort of cut these things by types of buildings. So whether it's a main home, whether it's a secondary structure, certainly a lot of people have talked about 3-season structures or things that aren't winterized, and whether or not you can do things in multi-unit buildings. Again, subject to what the goals are. Occupancy limits can be really powerful. You can do that by bedroom. You can do that by gross square footage. You can do that by simply a number of guests. And related to the next point, occupancy maximums regardless of unit size. We've seen some places say Airbnb says you can only list to 16 people. So no matter how many bedrooms you have, we're going to hold you to 16 people. Often that's a fire safety thing. Often that's a quality of life thing. And then I do want to bring up some questions about sort of in terms of what can be in a short-term rental, taxation and assessment changes. So there are ways to try to resolve this gray area of whether something is residential or commercial in form or function. I've seen places, Lewis, Delaware is one that actually has a rental income tax separate from, say, a hotel or motel tax. And then assessors all around the country are trying to sort out whether things that are not residences need to be assessed at a commercial rate, or whether that would throw things out of alignment if something is zoned residential but assessed commercial. A lot of states don't allow you to do that. Where, again, very important question, which is certainly, as Judy talked about, you can have zoning specific licenses and rules. You could create new zoning, although I know your map's already very complicated. There are plenty of places that create a special district or an overlay, and often that's the tourism overlay district. And they have different rules in those zones versus other zones. Some places say there are bans in certain, say R1 zones, normal low scale residential. There's a ban in R1 zone, but then you can do other things in other zones. Going back to caps, you can use zoning to do caps. You can set a cap by zone, which again, I think makes zoning officers wince a little bit, but people do it. You can do it by density, so you can choose a percentage of the number of housing units. Again, whether that's from the American Community Survey or the assessor rolls. You can do block face, so some sort of buffer between short-term rentals, whether that's a physical distance or say one per block face. And then other places use other geographies. In California, they have different rules near the seashore. I've seen some places try to limit the number around sort of other lodging groups. So you can't do certain sort of short-term rentals near hotels. Another big question, back to a zoning question, is whether something's as a right or conditional. You can make certain categories conditional in certain zones to give you extra control and a public comment opportunity, rather than just being able to walk in and fill out the form and get your permit. Weber County, Utah proposed this, which is a transfer of development rights, which is to say a short-term rental, a proposed short-term rental would subsidize some sort of other use on the island. In traditional transfer of development rights, it's usually around open space preservation. I've seen some places look at options around housing, whether that is something that's required if you want to do something in a zone that normally isn't allowed. And then on an extreme, not that we need more democracy on this day of democracy, but Chicago, I think they've now gotten rid of this, adapted their liquor laws to allow votes by ward as to whether they wanted short-term rentals or not, which is maybe a level of democracy America is not ready for at this point. When some of this is difficult in terms of enforcement, but I do think it's important. Certainly yearly day limits on the number of days you can do short-term renting. Sometimes that becomes the inverse of the number of days you need to claim it as a primary residency. You can do individual stay day limits, which is pretty common, I would say, in New England, where the minimum night stay is 7 versus 1 or 3. I've seen a couple places do seasonal permits where they try to have different rules for their high season or for their low season. In a broader sense, you can have a kind of timeout period, which I believe Maui does, which is there's a waiting period basically after you buy a property before you can get a short-term rental license, as a way to try to slow down sort of speculation or flipping. Certainly on the compliance side, there's going to be, you would want some sort of timeout, which is if you have a certain number of violations or some major violations, you wouldn't be able to operate for a year or 2 years as a way to ensure that sort of top level of compliance. The how is honestly probably the stuff that we all agree on, if there's a place to start, which is assuming there are short-term rentals. How is really about life's health and safety, quality of life. They're things that really you have to be pretty intense to argue against. So fire extinguishers, smoke and carbon monoxide detectors, appropriate egress, local contact person, basic noise, trash, and parking standards. That usually breezes pretty through. I think everyone finds that pretty unobjectionable. It's some of these other things that I think you do get a little bit pushback on. ADA compliance, I think, speaking to that equity piece, certainly traditional lodgers often are subject to ADA compliance. Residential structures are not. And so that can make it very difficult for people with disabilities to find lodging. This one is always usually popular, which is the ban on altering property for short-term renting. You can't just knock down walls, you can't pave over your lawn, those sorts of things. You want to maintain, at least in physical form, a residential look. Insurance, again, that's mostly about protecting hosts from themselves and from anything that'll go on. Special events, so can they host a wedding? Can they have food service is usually the big piece, and that some of the times comes from the state level. Record keeping requirements are, again, almost universal. You have to keep track of what you're doing. You have to make sure you pay the right amount of tax. So that was a long list of stuff. I recognize that was a long list of stuff. So what do you actually do with that? So what you can do is you can answer those questions, that who, what, when, where, how, and you can stack those answers. So you can say who, primary owner occupier, what, 3 bedrooms or fewer, where, are 2 zones, how, they got to have basic noise and trash and maybe extra parking, right? There you've built out a profile of the type of person who can now engage in this. And all of those answers should lead to the goal you've defined or what you're trying to view as success. It allows you, as you go through the drafting process, to do a kind of internal check as to, are we introducing things into a bylaw or into what we're writing into an ordinance that is unharmonious or heads in just a different direction than all the other things that we think is pulling towards a kind of profile of the activity on the island. You can break it so that you do understand how each of those pieces shapes a market response. So you can begin to start to anticipate what those might be. And it does allow you to prioritize certain specific elements for enforcement. So certainly a lot of places want to look at that definitional side of things as the driver of compliance. We want to make sure that everyone has a permit, that they're the right number of bedrooms, they're the right operator, they're the right zoning, more so than the quality of life concerns, which are much more difficult and more expensive to do enforcement on. And so I want to give a couple examples. Newport, Rhode Island is a really fascinating one. They changed theirs just this spring. They really only have, I know it's laid out as if they have two permit categories. They really don't. It's just 2 spins on a short-term rental within their sort of categories. And you have to satisfy all of the pieces on the left in order to be that piece. If any of them are not satisfied, you automatically go to this other more regulated piece on the right. So they have defined a category that is a owner-occupied rental that is a maximum of 2 bedrooms and a maximum of 4 guests. It is owner-occupied. I believe it is hosted, which means the owner is theoretically there. You can do that in any zone that property is allowed, residential property is allowed. You're held to a residential building standard, so your normal house. You can only do it in 1 unit per lot. So if you had a ADU or you had a mother-in-law suite, you can't do 2, you can't do 3, you still only can do 1. And they have what they would prefer you not touch your parking. If you don't have parking, you don't have parking. If you do have parking, then great, but they don't want you to really mess with your lawn or do anything else beyond that. If you don't satisfy any part of that, you become a guest house. So guest house on some levels are broader. So you can go up to 5 bedrooms and 10 guests. you don't have a hosting requirement. You don't have to have someone on host in certain districts. In business districts, that's as a right. So you can just walk in and say, I don't live here, but that's fine. It's under 10 guests, it's under 5 bedrooms. There are special districts where it becomes a conditional use, right? So you'd have to go before the zoning board to get that approved. And then, you know, it's not allowed in residential zones. So if you owned a property in residential zone, even if you're owner occupied, and you wanted to go to 5 bedrooms, you're not allowed to do that. And that's something they changed this spring. It has a commercial building standard when it comes to the fire marshal inspection there, which is a higher level in terms of even things like sprinklers or fire curtains and stuff. Same 1 unit per lot, and they have a slightly higher parking requirement in some zones. So that's how they've divided this structure. There's also very specific rules if you're a yacht crew. That's a different thing, but they have this category which is allowed in these residential zones, but it has a lot of requirements to it in order to satisfy their ordinance. So that's Newport. Did want to talk about San Juan Islands. For people who don't know the San Juan Islands, it's the West Coast parallel, I would say, in a lot of ways to Nantucket. It's a place where there's still people who fish for a living, and then, you know, Oprah owns a property there. It's a very, very strange mix. It became very, very popular to visit during the quarantine. Now, if you look at their ordinance, it's actually really straightforward. You can do it in a single family or an ADU. There's no residency or hosting requirement. Pretty small number of guests. It's 2 guests per bedroom plus 3 guests. Although if you had a 5 bedroom place, that would be 13 people. They do have a parking requirement. It is Washington, so they're a little more dependent on cars there. Still a residential standard of building. You do need to send out a management plan about how you are going to deal with all the quality of life issues to every neighbor within 300 feet. But what they are doing in order to try to slow down the huge changes they've had over the last couple of years is they've set a cap number, and it's a cap number below their current number of permits. And so they are doing a moratorium and attrition. So they're trying to, over time, get to a certain number, which will be their new cap. And then once that number is achieved, then a wait list will open. But until then, they won't even start a wait list. There's no wait list to be had until they get to that cap number, which could be next year. It could be in 5 years. They're not really sure, but that is where they've started. And then I did want to bring this up because someone mentioned I was very excited to hear, which is Kennebunkport. They have 2 tiers of permits just based on the number of bedrooms. As far as I could tell, the only difference is your permit cost. Again, a very similar occupancy to you see in San Juan Islands. It's actually very common across the country, which is 2 guests per bedroom plus 2 guests. But they have a cap, and it's a very, very unique one, which is in Goose Rocks Beach. And I don't know Kennebunkport, so I'm not familiar with what Goose Rocks Beach is. There is no cap. There's no restrictions at all. I think they're at 23 or 24% registered short-term rentals of this last year. Across the rest of the town, minus the units in Goose Rock Beach, both long-term and short-term, the select board sets a cap number. And that number in 2022 is 9.5% of housing units are allowed to be short-term rentals. Now, I don't know how often they intend to change that. I don't know if they have some sort of federal board solemn ceremony where they open up the envelope and reveal a new number. But that is the structure of their ordinance. Within that, they do have a residential rental accommodation, which is a hosted stay, owner occupied, no more than 2 bedrooms. Very specifically, no separate entrances for short-term rental rooms. So it is a true hosted stay. You have to come in the front door like everyone else. And they have a stay limit. So it's a 7-day minimum stay limit, even for these hosted stays. So what you see here is 3 places that have answered these questions in a very specific way to their context. And what is interesting to me, I think, is all of these things are set to establish some sort of baseline in terms of the potential number of, or not even the number, but the potential impacts, let's say on housing, the potential impacts on quality of life, and this idea of neighborhood cohesion. They're set up in such a way in order to really answer that question of what is the shape of this market going to be in town. And I think that's one that, from the discussion we've seen today, is kind of the one of the most important questions, which is how do we define the shape of the market? And there's always going to be some people who are going to have to shift what they do. But within that, you want to move things so that it is, I would say, achieving the goal that you set out to do. So that was a lot of information. I spoke too much. I really need to take a sip of water. But I think it starts to help you organize ideas that are swirling around into those kind of recognizable questions, which gives you maybe a sense of how to present things and how to keep the conversation moving forward and on equal terms. So that's all I have to say. Thank you.
Thank you. Thank you so much, Jeffrey.
Mhm.
Bring that down. So, right, as you all can see here, it's sort of what we are trying to do. As much as everybody says, let's all just agree on what we're all here for, knowing there are differences of opinion, I wanted to make sure that you all see the wide range of tools that are available. And I think we're kind of going to work in both directions. That is, we have a broad sense of what we're trying to accomplish. And now we have a whole set of tools. And we want to kind of, let's play with the tools and let's see what that has to say about what we're trying to accomplish. And then let's tweak the tools and let's then see what that has to say about what we're trying to accomplish. Right. And it lets us sort of go at this problem from both directions. And to just put forward, like, there's a lot of options out there for us. And the hope is, even with not exactly the same idea of what we're all trying to accomplish, we may be able to really find a set of approaches that we all can accept and live with and find valuable and or tolerable for moving us forward together. So let me give a moment for questions if any have any pressing questions. But beyond that, I think maybe before we turn to public comment, I wanted to maybe put forward our a proposed potential game plan for where we go next, because you all have asked. But first, just any questions for Jeffrey right now from what he's presented? He's stunned us all into silence with his good information. Okay, so let me then just very quickly share with you.
Stacey,
Yeah. Oh, Kathy, go ahead.
Thank you. Just real quickly, Jeff, whoops, let me took my hand down. The missing data that you identified in the last presentation with the real estate agents, associations, to get all that data there. What are your plans for filling that in? What kind of timeline can we expect? And what specifically do you need from them, given their limitations as to providing specific names and license numbers and so forth?
Yeah, great. So something I've been working on over the last week and a half is to do a lot of the same procedures that we do with the your Airbnbs and VRBOs of the world, but do that with the real estate listing sites. I had 4 or 5 identified for me as sort of the most important ones and the biggest ones to start with. And so we are using our same tools that need to be adapted slightly to similarly scrape that information. In some ways, it's a lot easier because real estate sites, of course, give you the address. which means you don't have to figure it out yourself. So we're in the process of doing that and trying to figure out how to make sure all the data points align, and whether that needs to be kept in a sort of different spreadsheet essentially than some of the other data from Airbnb or VRBO, because the data points don't really align. And then
You'll be able to deduplicate that data, do you think?
and then also deduplicating it so that we understand, because there are quite a number of things that are posted on multiple real estate sites and on a internet platform. So
Are you able to get usage information? I know you get a snapshot, so you really can't go back and see, because I know they have a lot of aggregate information that might be useful, but then you wouldn't have that on the platform side.
yeah, I mean, this is a problem too with even, say an Airbnb. We have ways of doing some estimations. A couple of the real estate sites do have calendar features, which allow you at least some idea of maybe when it's blocked off, although that only tells you so much, right? That doesn't tell you necessarily maybe the family that owns the place is there that weekend and that's why it's blocked off. So there are lots of grains of salt with that. And that's one of the things we're trying to work out, is what can we be confident about? What can we be less confident about? What is something that we'd love to have, but we just don't think it exists out there. So we're working.
I guess one of the things that I think a lot of people would like to understand better is that has there been a lot of growth in short-term rentals? Is it growing? Isn't it growing?
Mhm.
And I don't know, I haven't seen that you've been able to pull any of that because you can't go back in time. Is that correct?
Yeah, there's some limitations on that. We have some estimates on some of the sites about when certain listings were created. That again is only going to tell you so much, because maybe it was under the table, maybe it was through a real estate agent 5 years ago. That so we're a little limited in that. We can do things about absorption, so we can see if a unit was built and then immediately became a short-term rental, because we have the assessor's data. We can see things about when certain listings were created based on after a sales date to say, okay, well, that something shifted there maybe. But it's a real difficult struggle to get certainly very specific data down to the unit level. We do have some access to more aggregate data or island-wide data. That's only going to give you some trends. It's not going to always be as specific down in, I mean, we're talking about zoning. There's a point where we kind of, it gets out of focus as to how granular we can get on some of that data. So we will take it as far as we have that information, and certainly talking to some of the real estate folks on the island, some of the data they have. But again, that's going to be often very aggregate, maybe by neighborhood, but we'll take it as far as we can and be as granular as we can. But there are some limitations certainly over time. Yeah.
And are you looking at, do you have access to data, like sales data from them, like who's buying the homes that are turning over?
That would come from the assessor. Yeah.
Yes.
So
you
we
can get
have
that from town as well. Okay.
Yeah, that's another step, is once we do deduplicate this, Megan put me in touch with their GIS guy to do a bulk download of the assessors for those specific addresses that we've identified. So I don't have to comb through every property record for the island over the last 10 years. It will be specific to properties we've identified as being short-term rentals by our definition, again, which is under 30 days. And so from that, we'll be able to maybe start to get some patterns. The hardest part is certainly long-term rental data. So if someone wanted to rent a place for a year, that data is really difficult to find, which is unfortunate, because it'd be nice to be able to compare more of the data we have to a more granular, rental figure for a long-term rental. It's very difficult to find in a way that isn't so aggregated that it's kind of not as meaningful as you want it to be. So, but yes, so we'll get that through the assessor, which would have the name and address of whoever bought it and the price they paid.
All right. Okay, so let me quickly share my, at request of members here, how are we going to move this forward? And I particularly want to flag the potential for trying to have an in-person or hybrid longer meeting, maybe on December 5th or 6th. So next meeting, my thought was that we're gonna hopefully get some of this data. Jeffrey, just to check with you that that's a realistic timeline for you to be able to bring us what you have. Does that seem?
I believe so. There's always going to be more data questions, but I think at that point we'll have a much more robust understanding of the short-term rental market and started to get into some of these questions about the changes that have occurred in the long-term market. So that's the plan.
Great. So really to focus the next meeting in on that. And then to, I know there's a lot of eagerness to make lots of progress fast. And so one thought I had is to try to have a longer meeting in person on December 5th or 6th. We're still looking into what kind of availability the town might have to have a room in case we still have people who need to be remote. And we would just have to be really creative in how we set up that meeting so that we can really be productive together. And my thought there is to really start working on developing some initial packages of policy approaches that will really connect to the purposes and goals that you all have. So to evaluate them based on, well, how well does this meet this goal that we're trying to do? How well would this one meet this goal? And really try to work on that. And then the thought of maybe having a public meeting, a virtual public meeting, where we give the public a chance to start to evaluate if we have a set of packages that we've developed, that the public can start to evaluate and weigh in on what they like and don't like about these different packages and why. Come back together on the 20th and synthesize what we've learned from the public, start to really evaluate those options more, and perhaps even start to see if we can select a preferred approach. If we could do that, we could see if we can get some draft language written up by early January and start to evaluate that and potentially try to finalize something by the 17th. Now, this schedule would work for general bylaw. It would work for potentially creating a zoning one, but it would not give us enough time, even if we could create a zoning bylaw by this time, to put it up for this year's town meeting. So this is really a fast track work plan for if we are trying to get a general bylaw to put forward for this town meeting. Peter.
I would, I think having a meeting in person would be great. I would really urge you to do that on the Monday, the 5th, because there'd be many of us arguably who might be coming up for stroll, who can maybe stay an extra day, but not 2 days. That's one thing. The other thing, I mean, as far as the in time for town meeting, I would just underscore what I think we discussed last time. I think we ought to be in a position at the time of the town meeting that to tell it, to say we want a special town meeting in the fall, and put out whatever we have up and say, look, this is worthy of discussion later, and put that up against anybody who may have proposed something, and hopefully that will convince them to move things later in the fall.
Okay, thanks. David?
I really appreciate, Stacy, you kind of inserting a sense of urgency here. I think it's a needed part of what we're doing here. I just have a concern with us creating packages of regulations or whatever I feel strongly we shouldn't be regulating for the sake of regulation, and that we need a metric to back up that regulation. So I'm concerned about starting to talk about packages before we really understand what we're regulating around and why we're regulating that piece. Just a thought.
Yeah, no, I think that makes sense. And I can imagine a way to do that, explore this together, where maybe what I don't want to do is wait until we have consensus on what we're all trying to do before we try to develop some packages. So I think I want to try and find some middle ground where if we can meet in person, go into some different small groups to try and develop, okay, here's the package that would focus on these things. Here's a package that would focus on those things. And try and so that we maintain some flexibility and creativity rather than trying to just pick the one thing and then fight about that.
Yeah, no, I didn't mean that in a bad sense. I just don't want us to waste time creating regulations that we're not going to use, or there's no metric to back up the use of them.
Yeah, for sure.
Thank you.
Peter, you're unmuted.
Sorry. We're rushing because one member and one group wouldn't support our original statement of our ideals for this case. And so we're rushing to present something to the town so we can compete with Julia. And I think it's silly. I really think, I have to tell you, I was on the committee that put this together with Dave. Maybe Dave remembers it differently, but never did we discuss that this would be ready for this town meeting. I think having it for a special town meeting was even ahead of what we had thought, but that would be great. But I think discussion thought this could take 2 years to do. And we're talking about a major, major impact on the town with whatever we decide. Now, I understand, it's almost like a football game here. We can't let the other team score. I'm not saying what team I don't know what team I'm on, but just because we have one team who's ready to put their objectives on the line, and I think it doesn't make any sense because it kind of defeats the purpose of our committee, but we've discussed that already. So what I might think that something that might make sense is for us to put some articles together for a town meeting that are quality of life articles that relate to what we're doing, but don't specifically talk about what we're going to ultimately come up with the short-term rentals. And when I'm talking about car regulations, one of the things that I was thinking about was we have all these swimming pools going in and everybody's complaining about swimming pools. Well, damn, make every person who puts in a swimming pool, put an attachment connector on there that the fire department can access their water if they have to. I mean, I live out in Tom Nevers. I have 3 pools around me with 150,000 gallons of water and no fire hydrants. So my house could burn down when my neighbor is going swimming. There's lots of things that we can do as a group to improve the quality of life without rushing to make a decision on something that's going to affect the entire island going forward in a big, big way. That's it.
Okay, thanks, Peter. John.
Well, Stacey, if you could put up your chart again, it'd be helpful. But before you do that, I would say I think that is an excellent approach, and I, respectfully disagree with Peter. And I do think that kind of timeline would be good. And if you could put it up again, my only, I guess, thought is, could we have another meeting, even if it's a subgroup meeting? Is there meaningful work we could do at a meeting next week rather than wait for 2 weeks? But I love it. I think it's a great approach. But if we can do something next week to move it along, if we cannot, Stacey, that's fine. But if there is some work some or all of us could do, let's do it.
Okay, thanks, John. All right, I want to thank you all for all of this. And, I know this was an education-heavy meeting. We had 3 really great presenters sharing a lot of information, a lot less on the discussion side for all of you. So I imagine that you all have, you'll have your homework cut out for you maybe to go home and really think about what comes out of this for you, any key takeaways, and maybe what we can do, John, as a middle ground in between is we could just do a little poll or survey where you all have a homework assignment to think about some things, and where is this leaving you right now, and what are the priorities you see, and some things like that we might be able to collect to have as input coming into the next meeting, rather than just coming back together and talking. We could actually do some asynchronous work, ground running when we talk next. If that's
For me, that would be perfect, Stacey.
okay, great. Kathy, something you want to name?
Just quickly, when we had meetings before, at the very last end of the meeting is when you put up, here's my new schedule, here are my dates, and we're asked to just, we don't really have time to think about it ahead of time. I would just ask, especially because it's all holidays and traveling and so forth, that if you have a plan like that going forward, that you kind of give it to us ahead of time or put it as part of something, so we have some time to think about it before the meeting's about to go and finish. That's all.
Totally fair request, and my apologies. It's tentative and working on many fronts at once, but
I rearranged my whole schedule so we could have those Tuesdays, and now you just stuck some more in there, so.
I appreciate that. The only other thing I put in there is the 5th or 6th, but I hear only because of, I think, some feedback I heard from people is having it in person adjacent to a weekend might be more helpful.
I think the 6th was already our meeting. It was the 13th. That's the one that's new.
Yeah, the 13th is meant to be a public meeting. So, okay, thank you for that, Kathy. All right, I want to turn now to the public comment. You all should be able to raise your hands now. And just to request that you please identify yourself with your name. Please speak on the topics from today's agenda, if at all possible. We'd really appreciate that. Please limit your comment to 2 or 3 minutes. You're also welcome to type any comments into the Q&A, and we will try and get answers if you have questions going forward. So Carolyn, we will allow you to speak. You should be able to unmute now.
Caroline Baltzer, is that who you're calling on? Yes, thank you. I'm just commenting on, well, I've lived at 66 Hulbert Avenue. I'm trying to follow along as closely as possible. It's all very complicated. Excuse me. I really like what Peter Schaefer just said regarding, excuse me, regarding how quickly this is moving along. And I've paid attention for this whole meeting, and I'm still trying to figure out why it's trying to be fast tracked. As far as I can figure, the information about the majority of rentals, which is coming from the rental agencies on the island, hasn't been included in the data set, at least in no way that I can see. I have a statistics background. I can't find anything about that. So it makes it hard to, even for me, to frame what the problem is. And I know you guys are trying to figure out what the problem is so that you can proceed. And I'm not hearing that clearly defined in this meeting. And therefore I'm confused about how all of a sudden it's getting fast tracked. Thank you.
Thanks. Campbell Sullivan. You should be able to unmute yourself now. But you're still muted.
I just asked you to unmute, so you should see a button that prompts you to unmute.
Are you able to unmute? We've so far not able to unmute.
Stacy, maybe go to Robin while we wait for Campbell.
Okay, Robin.
Hi there. Yeah, I just wanted to echo the last what the last speaker said, and also Peter's point, because as I understood our group in this effort, the commitment, a big part of the commitment was to be data-driven. And we've heard a lot about what Granicus has said about the way they're going to go about gathering data, but we don't have it. And so I don't think it really makes sense, you know, as Dave said, to put things forward that we can't defend with metrics if we are trying to craft regulation and we don't know if we're solving the right problem. So that's just one piece. The other thing is I wanted to really commend the gentleman from the law firm for, I think it was Alex today, because the definitions, there are 4 loaded words in this debate. Well, particularly loaded, there are lots, but the words commercial, the words investor, the words primary, the words residential, those really must be defined, because oftentimes owners, families who use their home every year for 30 years, like Ralph Keith, who's currently the subject of a lawsuit, who was labeled a commercial rental. Yet his family, he owns one home and he uses that home every year. So it's really key that definitions, that very close attention is paid to exactly how we are defining, because the words commercial and investor get thrown around a little bit too much. But data, I really think we need to not rush before we have data to craft policy. Thank you.
Thanks, Robin. And yeah, hopefully, I mean, as we heard, we're going to get our first batch of data at our next meeting, and we'll see where people feel we are from there in terms of, do we have enough to go on? Okay, Campbell Sutton, we're going to try again. See if you can unmute.
Did that work?
Yes, there you go.
Did that work? Hello?
Yeah. Yes, we can hear
Super.
you.
Super, thank you. And Stacey, I just want to thank you so much for putting this together and having those wonderful presenters. I felt like they gave us some great information to work with. So yeah, a lot of great information. So I guess I just wanted to run through a few things, because I know you said something about 2 minutes. I wanted to try and keep it to that. So I was thinking that if for this group, because I know there's some tension about trying to, meet the deadline for the ATM, I was thinking if you could aim for a broader general law to help us sort of begin the definition, because I understand that need is driven by just starting to get some regulations on the books. It's sort of electric bikes. We didn't do anything, and now they're everywhere and they're going too fast. And it's hard to put the horse back in the barn. So that was one thing. I was thinking something along the lines of 3 tiers, based on that New Orleans Fellows presentation, where you have sort of a owner-occupied kind of thing, and maybe you have a residential use where someone has maybe like 1 or 2 properties that they use, and then you do something that's like over 2 properties. one of the things that has interested me is if you're an LLC, that means you're a limited liability corporation. To me, if you are property that way, then you're a business. Just outright, right? You're a corporation, you're removing yourself from responsibility from what occurs on the property. But I also know that's tied to estates too. So there's that piece. We've been expanding commercial neighborhoods a lot through the planning and zoning. So I think that there are areas where these types of commercial rentals could occur and not impact residential neighborhoods, because neighborhoods are pretty important, I think. The other thing I thought that really hasn't been addressed, and it's something I've been reading about, is enforcement and trying to tie the enforcement to the renting app or the realtor, so that each property has a certificate, and that certificate is publicized, right? So that when a property is under whatever definitions one arrives at, is rented in a illegal way, that the enforcement falls back on the app or falls back on the realtor seems to be more successful in areas that are doing this than ones where you're trying to actually address the individual owner of a property. Do you see what I mean there? So
And
I know I've been
sorry,
going
can I
on.
ask you to wrap up now?
Yeah, I'm going on, so I'm just gonna stop.
Thank you.
So thank you for your time, and I appreciate everyone's thoughts and comments.
Thank you. Rick Atherton.
Yes, thank you. Just sort of an observation of the local interest in this topic. People I talk to, a number of them are concerned that delay beyond the next annual town meeting, or however long it takes for this committee to come to some recommendation, is primarily in the interest of the short-term rental supporters. And that's why I think there are a number of articles that might well pop up, even if it takes calling a special town meeting in March. So I hope you'll move the process along quickly as you can. Delay is not good for the community, in my observation. Thank you.
Thanks, Rick. Bob Bedoni.
Hi, actually, I'm Virginia Bedoni. Hi.
Hey.
So we've owned a house on Nantucket since 1999. We spend about 3 to 4 months in our house, and we also rent it. Our neighbors rent. We have good relationships with all our neighbors. We're spaced pretty far apart. Our houses, the ones that rent, are actually, it have to be in excellent shape. Otherwise, they don't rent. People don't come back. And it's kind of ironic to me that you have people crowded in employee housing, people renting houses for a year long who are stuffed to the brim, and we all know this, that are not meeting code. And so, you know, if you're trying to regulate the houses that we rent out, I can tell you quite frankly, we're in a competitive market, and our houses have to look good on the inside and the outside, and they have to be safe. Otherwise, people don't come back. So I have to say, I am really offended by having anybody call us a commercial owner. We are a family and we rent to families. And these families have been coming back year after year after year. And they come with their kids, and their kids love this island. And those are the kind of traditional rentals that have been going on for years. And so I resent if anybody would call us commercial owners. That's So that's all my little rant goes tonight. Thanks.
Thank you. All right. Well, with that, I see Kathy. You have another comment, and then we'll take any final comments and close out.
Okay, I just, speaking as a public person here, I just had a couple of questions for the Board of Health. And I wondered if I could just ask them, because Mary is on the group with us, and maybe she could answer them or pass it along. One has to do with the short-term regulations that are about to go into effect, the insurance liability that's required. And somebody noticed that the wording in that requirement for the $1 million of liability insurance in the town's regulations is worded differently than the state regulations. So the question is it intentionally different? Is it just transposed differently? The town is requiring $1 million per event, and the state requires $1 million per rental, which is different. And insurance companies wouldn't necessarily write a different line of liability insurance, for example. So that's a question that we have been asked several times in writing and haven't gotten an answer. Some people have been asking me, did I know? And I don't. So that's one question I have. And then also that when we heard that when these STR regulations were approved by the select board in, I think, September 21st, it's almost, pushing on 2 months since those were approved. It was noted there would be a public outreach campaign to educate everyone on these regulations and perhaps post FAQs, which would be assumed would include an opportunity for feedback, because this is a brand new practice for the Board of Health. Since these regulations are going to go into effect in 6 weeks, I believe, I just wondered has there been any progress along those lines? If the Board of Health is working on them, can they share that information with the group? I think it would be really helpful to have that for everyone to know, just so we understand what's going on with that in the application process. So those are just the 2 questions I had.
Sorry, I don't know, Mary, do you want to answer those now? It wasn't.
I don't really have an answer for them. I know that an outreach was discussed, and I think that there weren't going to be any penalties this year for people if they hadn't registered. It was really seeing who was registered compared to who we know is there. So I can certainly ask the Roberto and everyone where that information is, and email you, Stacy, to send out to everyone.
Yeah, that'd be great.
That'd be really helpful, I think, just, and also to get an answer to the question on the liability wording and why it's different. I think that would be just people asking. That would be great. Thank you so much.
All right, and I do see we have one more attendee who would like to make a comment. So Henry, you should be able to speak now.
Okay, thank you all very much. I would just emphasize the importance of talking to the NARAB members. I am a member, and we did perform a study of frequency by length and area, and then frequency by area amongst several offices, and that gave us kind of a baseline for where rentals were occurring. I also think that it's very valuable to talk to people who have been in the industry longer than I have, and have seen the vacation rental market evolve pre-internet and post-internet. And really what a lot of what we're dealing with here is the proliferation of booking mechanisms versus, so for example, just very quickly, back in pre-internet, families used to write to real estate agencies saying, please find us a rental, and include like a picture and a biography, versus now they just send it a message saying, I want to book this house. So it's also about like how available this is, and can we regulate that? And then the last thing I'll say is just to Mr. Atherton's point. I think that is the lawsuits, and for the most part, I think vacation rental owners who I've talked to would like they would like to end this. So I actually disagree with him respectfully, because most people that I know who have vacation rentals, myself included, we want clarity. We're afraid that we might be the next people to be sued, which so far has ended up in people selling their homes. So I think that stringing it out is in no one's best interest, but at the same time, it also should be noted, most houses for next summer are already rented. You're kind of regulating into a year already done, and more data is going to help you be more specific on how you regulate something that has many, many facets and many different types of owners and acts very, very differently than a homogenous one phrase definition. So that's it. And thank you all for your work and your time. I appreciate it.
Great, thank you so much. All right, everyone. It's been a long night, and thank you all for sticking with it all. We'll send around some questions, some homework for you all to collect before our next meeting. And yeah, we'll also send around a poll for timing for in-person and public meeting. And we will see you all in 2 weeks. Karen, something else you want to say?
Just really quickly that I'm very committed to trying to get up there, but the sooner I know, the better, so I can make some plane reservations and various arrangements. So
understood. Great. All right. Thank you all so much. Have a great night and rest of your week, and we'll be in touch soon.